At 9 o'clock on the clock on the wall. We don't have computer time today, so I'm going to go ahead and call this hearing into session. And at this moment, we're preparing to move forward with hearing procedures. That'll be item 1.2 on the agenda, folks. And so typically at this time, regarding the hearing procedures, I turn this matter over to our school board attorney, Mr. McInnes. Mr. McInnes.
Thank you, Mr. Chairman. The school board is in session this morning to conduct an employee appeals hearing in the matter of William Andrew Johnson versus the School District of Okaloosa County, Florida. This hearing is being held on the petition for hearing filed by Mr. Johnson, filed with the district on February the 14th of 2019 in response to a recommendation for termination of his employment by the superintendent. The procedures this morning, under this matter, the school district has the burden of proof to support the recommendation for termination of the employee. Therefore, the respondent school district will present its case first through its attorney, Mr. Robert Larkin. Mr. Johnson's attorney, Ryan Hardy, will then have the opportunity to present his case in response to the district's case. Each party will have the right to call witnesses, and each of them will have the right to cross-examine the witnesses of the other party as they're called. At the close of both parties' case presentations, the board will need to deliberate here in open session to review and evaluate the evidence as presented and come to a decision as to the facts and conclusions of law. You then will need to reach a decision as to the employment termination recommendation, and as your attorney, then give me directions how to prepare a draft final order. Board members, you will need to be clear on the record with your directions for me in regard to drafting the final order. I will then use the fully transcribed record of this hearing to draft the proposed final order, which will set forth the facts as you determine them to be, your conclusions of law, and your final decision. That draft final order will then be presented to you with the full hearing transcript at another special board meeting for your review, revision, and approval. That meeting will be an open public meeting, but it is not a hearing, and no further evidence or testimony will be taken. It is a meeting for the board to approve and issue the final order in this matter. At this time, for the record, Mr. Chairman, I would ask that each of the attorneys for the parties make their appearance for the record.
Go ahead and come up. Sure.
Robert Larkin.
All right.
Jeff Champ on behalf of the district.
All right.
Ryan Hardy on behalf of Andy Johnson.
All right. Good morning. Good morning.
Board members, the parties have been asked to exchange witness list and exhibit list, and I can confirm for the record that they have each done that, and a copy of those outlines of witnesses and exhibits are part of the record of this proceeding. I would ask, Mr. Chairman, at this time that you accept for the record 3 exhibits that we will call school board exhibits. These have been stipulated to by the attorneys for the parties, and they are administrative in nature. School board exhibit number 1 is the letter petition for hearing from Mr. Johnson to the superintendent. The letter is dated February 12, 2019, and was received by the Human Resource Division on February 14, 2019. School board exhibit number 2 is the original order scheduling this hearing, which is dated March 1, 2019. School board exhibit number 3 is the order granting a continuance that was filed by the petitioner's counsel and rescheduling the hearing, and that order is dated March 19, 2019. And Mr. Chairman, I would ask for the record that you accept these 3 exhibits into the record of this proceeding by stipulation.
So accepted.
Then we need to review now the exhibits that each of the parties have proposed be received into evidence. And I will start with the list that was provided by counsel for Mr. Johnson. And we will label these, since he's the petitioner, these will be labeled P dash whatever their letter is. So Exhibit PA is the termination letter that went to Mr. Johnson from the superintendent. That would be the letter following the school board's action in this matter, and that would be Exhibit PA. PB is the recommendation letter that went to Mr. Johnson from the superintendent for termination. PC would be the employment contract of Mr. Johnson. PD is the grand jury report. And I have a question for the attorneys at this point. You've each listed that among your exhibits. Mr. Larkin, you have listed 2 such reports. Mr. Hardy, you had a general category of grand jury report, so is that encompassing the 2 that are there? Okay, so that will be PD for the petitioner. Exhibit PE is a deposition of Superintendent Marcus Chambers. Exhibit PF is an email from Arnold Brown to William Johnson. And Exhibit G is an email from William Johnson to Stacy Smith. Mr. Hardy, have I outlined all of your exhibits?
Yes.
Okay. And then in regard to, for the record, Mr. Chairman, it's my understanding, Mr. Larkin, you have no objection to the admission of those exhibits?
No.
Okay, so Mr. Chairman, would you then, for the record, please accept the petitioner's exhibits PA through PG for the record?
So accepted.
Okay. The next exhibits then will be those of the respondent school district. These will be labeled R dash whatever letter. And so Exhibit RA is a grand jury report of February 2018. Exhibit RB is a grand jury report of June 2018. Exhibit RC is a William A. Johnson termination letter. Exhibit RD is School Board Policy 08-09. And Exhibit E is School Board Policy 09-11. Mr. Larkin, have I outlined all of your proposed exhibits?
Yes.
Okay. Mr. Hardy, do you have any objection to the admission of those exhibits? Okay. Mr. Chairman, based upon that, would you please accept the respondent's exhibits RA through RE for the record?
So accepted.
Board members, that now puts all of the exhibits of the board and the 2 parties into the record. So as the hearing proceeds, when they make a reference to those exhibits, those are already admitted and those are available for you to consider as evidence in this matter. The parties have also exchanged witness list, and as I understand it from Mr. Hardy's filing, he has listed as potential witnesses Superintendent Chambers and Mr. Johnson. And Mr. Larkin has filed a witness list, and he has identified as potential witness Superintendent Chambers and Mr. Johnson, also potentially a district records custodian. I would like to once again confirm for the record that the parties did exchange their witness and exhibit information with each other, and are you each ready to proceed with your cases?
Yes, sir.
Okay. At this time, I would ask that they would, if both, I'll start with Mr. Larkin, if you would introduce your witnesses, and let's let the court reporter get the witnesses sworn.
Madam Court Reporter Marcus Chambers, Superintendent of Okaloosa County Schools.
Raise your right hand. You solemnly swear or affirm that the testimony you give is the truth, the whole truth, and nothing but the truth?
And Mr. Hardy, would you please introduce your witness and let them be sworn?
Madam Court Reporter Andy Johnson.
Sir, please raise your right hand. Do you solemnly swear or affirm that the testimony you give be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Let me return these documents to Mr. Hardy, and then we will be prepared to review. Are there any other procedural questions by either attorney or the board? If not, Mr. Chairman, it'd be appropriate to have Mr. Larkin present the district's case.
All right, Mr. Larkin, please come forward.
Good morning.
Good morning.
Members of the board. It is, it's my opportunity, I guess, to provide you a glimpse of what we anticipate to be the evidence today, to allow you to make a decision as to whether or not to retain the employment of William Andrew Johnson. With me is Jeff Champ, another attorney in my office, and the superintendent, Marcus Chambers. And today, you're going to decide whether to uphold the recommendation to terminate William Andrew Johnson, Andy Johnson. And many of you know him, and you've known him for a long time, and he's worked here for a long time. And you may be friends with him. I've known him. And I would consider him a good person. But we're not here today about friendship. Unfortunately, I think for all of us in this room today, and some of you who are new to this board, we have been sort of thrust into this role where it's not about personal feelings, it's not about friendship, it's about business. It's about what's right for the school district. It's about what's right for this community. And I want to tell you from I get in a car and I drive away and I go back to Tallahassee, and that's where I live. But I know, and everybody does, that this is a great school district. It has been a great school district since Mr. Gates and Ms. Tibbetts were the superintendents. Many of you all live in this community. Some of you have lived in this community and served in this school district for decades. This is a proud school district. It's an A school district. It's one of the best in the state. And you all, some of you, have worked and given your blood, sweat, and tears to make it that way. But I'm here to tell you it's not anymore. It's not. The perception of this school district locally and statewide is not what it used to be. And you know it. We were once a proud school district. We were the pinnacle, but we're not today. And it's unfortunate, when the governor of our state, in one of his first acts, removes our superintendent. Think about that. Think about that. When was the last time you heard that happen? Never. That is so unusual, and that is where we are, though. That is where we find ourselves. That is what we have been thrust into. We didn't do this. None of you did this. But we are all victims of circumstance. And so is Mr. Chambers. He didn't do this. He, like some of you, is new to this game. And I say game, and I mean new to this world of being a decision maker that has to make tough decisions based on what's important for the community, based on what's important for the school district, what is in the best interest of our students, not on friendship. Marcus has known Andy for years. They're not sideways. This isn't personal. It's business. And that's what I want you to focus on. I want you to think about where the school district is today and where it needs to go in the future to get back to where it was. And that is where Mr. Chambers finds himself. The governor appoints him as he removes our former superintendent, appoints Marcus Chambers as our superintendent. He's been here for more than 20 years, serving virtually every role that you can serve in this school district. He didn't ask for this. This isn't something that he is interested in doing in terms of he takes pleasure in this. He doesn't come in and want to start terminating people's employment. But he has to. He has to. When he comes in to this environment, Think about this. Superintendent has been removed. People have been found guilty of crimes and sentenced to prison. Other employees and administrators have pled guilty and accepted pleas and resigned. We are in the midst of chaos, really. I mean, we have criminal matters. The state attorney, we're in the paper every other day. You know this. The perception of the public is that this is not a good place for our kids to go to school. We're not protecting our kids. They're not protecting our kids. And that's what Marcus Chambers walks into. That's where he finds himself, like some of you, coming into this situation, finding yourself in the midst of this. And his primary focus when he walks in is how do I fix it? How do I begin to rebuild the confidence for the community, for the state, in this school district? What do I do? And that is the question. That's really why we're here. That's why we're here. It's not about Mr. Johnson personally. It's about what's in the best interest for this school district. How do we rebuild the trust in this community and in this state, in this school district, to watch over the safety of our kids? You know, I want to tell you, because it's an umbrella that's overarching all of this, that ethics and integrity mean everything. In this realm, this profession of education, ethics and integrity mean everything. We put our children in your hands every day to do the right thing. We rely on you every day to do the right thing. And your integrity and your ethics are paramount. Nothing is more important. And that has somehow been eroded. So when Marcus walks in, that's what he's in charge of trying to rebuild. That's what he's endeavoring to do now. That is what you all are endeavoring to do now. You new board members walked into this. You didn't create it. But this is where we find ourselves, like Mr. Chambers. Some tough decisions have to be made. Real tough. This is one of them. So there's a criminal matter going on. 2017, 2018, and it's lingering and it's dragging, and you all know it. It's in the paper all the time. The state attorney's in the paper all the time. Witnesses are being called from our school district to testify in front of a grand jury. Do you know what a grand jury is? It's 12 people in this community who are empaneled to listen to testimony from people to decide whether they're going to charge somebody with a crime. These are your citizens of this county, are empaneled to listen to evidence and testimony to decide whether they want to charge somebody with a crime. Think about that, you know? So we have this grand jury impaneled, and we put on, and the state attorney puts on however many witnesses, many witnesses. And it lasts days, if not months. And at the end of it all, the grand jury comes up with a report, whether they're going to charge somebody or they're not, with a crime, and take away their liberty and send them to prison. That is how important that decision is. So the grand jury issues a report. And in this report, Mr. Johnson is named specifically. Specifically, there are 3 people named in this report. That's important to note. It's noteworthy. Mr. Kelly, Mr. Johnson, and Ms. Jackson are the only 3 people named in this report. With respect to Mr. Johnson, he served in a capacity that we have to have the utmost integrity in, the utmost ethical responsibility, and he was, at times, as the grand jury found, primarily responsible for safety. He was the liaison between the law enforcement and this district. This is a criminal matter. This is his job. This is what he was hired to do, to serve as the liaison between the law enforcement agencies and this district. That's what the grand jury found. His primary responsibility is the safety of our kids, safety of this school district. And I want you to listen to what they wrote. He's not being charged criminally. He's not somebody that they're bringing in thinking of whether they're going to charge him. He's a witness, like dozens of others. But this is what they wrote, and I want you to listen to these words because this is important. They say, when answering questions before the grand jury, Johnson frequently answered that he could not remember. He also gave answers that were inconsistent with previous statements. It's a fancy way of saying he's not truthful. He didn't tell the truth. Let's just boil it down. When you give statements that are inconsistent with prior statements, that's called lying. It is what it is. While we do not find this behavior before the grand jury criminal, we do find it concerning and worthy of note in this report. So he comes in and he testifies, and they don't find him guilty of perjury, mercifully, but they do make a statement in here, and I want this to resonate. It is concerning and worthy of note. Now, why would a group of 12 people in this community, listening to a witness testify, make that statement? Why would they go out of their way to tell the public, the school board, everybody, that this is concerning and worthy of note? They wanted you to know. They did that purposefully. This grand jury is sending you a message. Sent the state one, sent this community one. It is worthy of note. They didn't have to do that. They could have said nothing. They could have left him out of the report. But they didn't. They didn't do that. And so when Marcus Chambers becomes your superintendent, and he starts reflecting on what has happened and what has transpired in this school district and the most extraordinary circumstances we find ourselves in, he opens up this report and reads that. He reads that a grand jury found Mr. Johnson to not be credible. He's the person who has to be credible. That's his job. Integrity and credibility are everything. And if that's that statement, it is worthy of note. Think about that for 12 people who are citizens in this community to go out of their way to inform you and everyone else that he's not credible. And that's why we're here today. When Mr. Chambers read that, it's deeply concerning, it's troublesome, especially to have somebody in this capacity, somebody that we need to have the utmost integrity, who is not credible. he had to make a decision. It was a tough one, like I mentioned earlier. He has no ill will against Andy. Andy and him are friends. They have been. But this is business. This cannot stand. We cannot have employees, administrators in this district who the grand jury informs us are not credible. We can't have it. So he made this tough decision. He made the decision to terminate an administrator. And he made it on this. This is it. This is it in terms of evidence. You're going to hear him testify. This is why he made the decision. Perception. The public, this community, the state, I think the perception of this district has been tarnished, diminished. He, like you, is in charge of bringing it back, restoring it. It's a proud school district. It's a great school district. You guys have done a great job, and you know you have. The teachers here and the administrators here care a lot about this place, and they've done everything in their power to see it be the school district it is, but it's not right now. It's really not. And the only way we get it back is by making tough decisions and moving forward in the best interest of the school district, the best interest of these kids. And you're going to hear Marcus testify to that today. And that's why he did what he did. And that's what the evidence is going to show. And we're asking you to uphold that decision, that recommendation, in the best interest of this district. Thank you all.
Thank you, Mr. Larkin. Mr. Hardy?
Chairman, if I may, we don't have the grand jury or the other documents in front of us. Are there copies of those that we can have available?
Yes, sir.
We have one copy or a copy for each? How does that work?
Jan can go.
We've made them before
Yeah, Jan
in previous hearings, so if Jan...
While he's opening, we'll let Jan go make these additional copies for him.
Sounds very good. Thanks.
Thank you.
Stand by, Mr. Hardy. Okay.
Yes, sir. We want to start, or we
Yes,
want
sir.
to wait for-
Please proceed.
Okay. Good morning, and first of all, say thank y'all for letting us be here. As I listened to Mr. Larkin, there's some things he pointed out that I completely agree with. Number one is Andy Johnson's a great guy. I've known Andy Johnson for a long, long time. Number two is this is a great school district. I can tell you that. I started in this school district in 1984. I mean, I made it this far, all right? But I will argue that I think it's still a great school district. We've got great folks in the school district, and it's going to continue to be great because of the people we've got in here. Now, he moved around, talked about evidence and all that. The evidence is going to show, well, it's not going to show anything. We don't know what Andy Johnson said. We don't know. Mr. Chambers doesn't know what he said. He doesn't know what was inconsistent. He doesn't know anything. He knows what he read in a paragraph. It doesn't say he lied. It doesn't say he's not credible. It doesn't say that at all. He's making a big jump. He's making a big inference. But he doesn't know. He's guessing. And we can't fire good folks because we're guessing. That's not how it works. Mr. Larkin, another thing I agree. Andy Johnson didn't commit a crime. It's in there. He says he didn't do anything wrong. He's not lumped in with the folks that did. There are people that did things wrong. There are people in prison. There are people who've been arrested. Andy Johnson isn't one of those. He's not lumped in with those folks. Cops haven't come handcuffed Andy Johnson. Nothing. He's done nothing criminal. And I want to make that very clear. He's not in that same category as those other folks. In fact, the report says he didn't do anything criminal. He was asked about things that happened, emails that happened, things that happened 9 months before. I don't know about y'all, but look, if you try to pin me down to what I ate for lunch on Monday, I'm going to have a real hard time telling you. All right? If you ask me about an email I got on Monday or Tuesday, that's this week, I'm going to have a hard time telling you that. The evidence is going to show Mr. Chambers has a hard time with that, too. He did a deposition where he said, I can't recall or I don't remember a couple dozen times. It happens. Nobody expects anybody to remember an email from 9 months before. But what he did do is he properly, when he got that email from Arnold Brown, and you guys have those emails, 32 minutes later he forwarded it and did exactly what he was supposed to do. He didn't ignore it. He took the email from Arnold Brown. 32 minutes later, he sends it to Stacy Smith and Mary Beth Jackson just like he was supposed to do. He did exactly what he was supposed to do. Now, that grand jury report says inconsistent statements. What does the word inconsistent mean? It doesn't mean lying. If I tell you that I ate eggs for breakfast this morning, and then we talk again this afternoon, and I say, well, I ate scrambled eggs for breakfast this morning, I didn't lie to you either time. But those aren't consistent. Those aren't the same. But it's not inconsistent does not equal lying. And Mr. Larkin kind of mischaracterized that, and he wants to talk about inconsistent and credibility. Those aren't the same thing. Those aren't the same thing at all. There's a whole lot of wild inferences, but just because you say something that's not exactly the same doesn't mean you're lying. I had scrambled eggs for breakfast, or I had eggs for breakfast. It's all the same. Mr. Larkin also used another buzzword. He liked the one credibility, but he also used perception. There's an old saying, perception doesn't equal reality. Just because you think something's that way doesn't mean it's that way. Just because they want to think inconsistent means lying doesn't mean it. Those aren't the same thing. Not at all. And that's what the evidence is going to show. The grand jury report is what it is. We've all read it. We know what it says. Doesn't say Mr. Johnson did anything wrong. And that's what the evidence today is going to show. Thank you.
Thank you, Mr. Hardy.
So it'd be appropriate now for Mr. Larkin to call his first witness.
On behalf of the district, we're going to call Superintendent Marcus Chambers. Mr. Chambers, could you state your name for the record?
Marcus Chambers.
And I know that you all know him, and everybody knows who Mr. Chambers is, but briefly, Marcus, if I may, call you Marcus, can you just tell the school district in general terms, how long have you been here? What capacities have you held?
So I've been with the school district approximately 21 years, a little over 21 years. I've been a teacher, coach, principal, district administrator.
And I'm going to take you to 2018, okay? In 2018, there's this criminal matter going on I think we all know about. What was your capacity as that was going on?
2018, I was the assistant superintendent over curriculum instruction, and then in 2018, I was the assistant superintendent over human resources.
All right. And you worked as one of several assistant superintendents under Ms. Jackson?
Correct.
And going into this year, January of this year, Ms. Jackson gets removed, right?
Yes, sir.
And you get appointed by the governor
Correct.
to be the superintendent.
Correct.
Tell the board how you saw your role, how you see your role from moving from one of many assistant superintendents to now the superintendent for this school district at this time?
Well, as you can imagine, so January 11th, I get appointed superintendent. And, at that time, for me personally, it, your life changes. And, this has always been a district. I think that has been a source of pride for this community, for the state. And I think it's fair to say that over the last couple of years, that's taken a hit. Do I believe we have a fantastic school district? Absolutely. But it's taken a hit. The last, prior to this, I was the assistant superintendent over curriculum instruction for 6 years. The last year also assistant superintendent over human resources. So everything changed for me in that moment. And one of the major pieces of information as I started transitioning to this new role, it was looking at the grand jury report. And within the grand jury, as you know, there's several witnesses that go before the grand jury. And as I go and look at this report, there's 3 in there, and Mr. Johnson is one of them. And as you all know Mr. Johnson, as do I. He's a great guy. He's in the grand jury report. In the grand jury report, as I read, like we've already heard, so Mr. Brown did notify Mr. Johnson of the Stillions matter back in May of 2017. But as you go deeper into that paragraph, it does say that Mr. Johnson could not remember, that there were inconsistencies with previous statements. And it did say that though the behavior is not criminal, that the behavior was concerning and it was worthy of note. So I'm in this new role. I think it's fair to say that there's a lot going on in this school district at that time. And a lot meaning we have a child that it was determined that was abused. We have 3 administrators that were arrested and that are no longer with us. And we have a superintendent that was removed. And I'd kind of call this unprecedented time. So this is my mindset right now as I'm transitioning into this role. So I did, at that time, consult with counsel. I did consult with HR. And I did come forward with a recommendation, and that recommendation to terminate.
I'm going to show you what has been marked and stipulated to us. Petitioner's Exhibit CPC. Is that the grand jury report that you reviewed, Mr. Chambers?
Yes, sir.
Okay. Now, when you became the superintendent in this context that you just described, did you set any priorities? Did you set any goals of what you wanted to do?
I did, and there were several, but as it pertains to here, one of the first responsibilities in my mind was to reestablish trust in the community, reestablish trust in the school district with our employees, and that was a major focus of mine at that time, and still is.
And when you reviewed the grand jury report, and with respect to the paragraph set forth pertaining to Mr. Johnson, what was your reaction?
So once again, I go back to great guy, but when I read in here, and of course, it's been stated, I don't know all the background. I don't think anyone knows all the background in terms of the grand jury, but when I read in here, and it's one of 3 individuals mentioned amongst the many witnesses, and Mr. Brown called them inconsistencies with statements. That was concerning. And then the statement of worthy of note, that they did go out of their way to put Mr. Johnson in the grand jury report, that was my mindset.
Did you consider their findings of inconsistent statements to be just a difference between eggs and scrambled eggs?
I did.
So you make the decision to terminate him, and you communicate that to Mr. Johnson, right?
I did.
I'm going to show you what has been previously marked and admitted as Exhibit B, RC, sorry. I'm asking if you would identify that, please.
This is the recommendation for termination letter that we gave Mr. Johnson.
And is that your signature at the bottom?
It is.
And so you authored this letter, and in this letter, do you identify any policies that you think Mr. Johnson violated?
I did District Policy 09-11 and our School Board Policy 08-09.
And do you identify any portion of the grand jury report in that letter?
Yes,
In fact, you quote from it, don't you?
I do.
And you quote from the specific issue that you just testified to, didn't you?
I did.
Do you think, as superintendent of this school district, that you could have somebody serving in Mr. Johnson's capacity who was found by a grand jury to not tell the truth?
I do not.
I'm going to show you what I was going to mark. And I apologize for going back, but we marked these as exhibits and then we entered them as different numbers and letters, so I apologize. So these have been previously marked as RD and RE. RE being our policy, Chapter 09, Personnel 11, which speaks to duties, ethics, professional conduct of the school district. What in particular were the provisions of that policy, Mr. Chambers, that you were relying upon?
So in this policy, 09-11, Section A, 1 and 2, it says administrative, managerial, professional/technical personnel shall at all times demonstrate, sorry, I apologize. Administrative, managerial, and professional/technical personnel shall at all times demonstrate, in 1, competence commensurate with job requirements and delegated responsibility and authority, and 2, ethical and professional behavior of the highest standard, and then also B of that policy that lends itself to administrative, managerial, and professional/technical personnel are expected to uphold the duties of the Code of Ethics and principles of professional conduct for the education profession in Florida.
Did you consider Mr. Johnson's testimony before the grand jury and their findings that he was inconsistent with his statements? Did you think that that was ethical and professional behavior of the highest standard?
I did not.
So in this policy, 0911, in Section B, we adopt the duties and ethics and professional conduct of 0809 for teachers, and we apply it to all of our personnel. Is that right?
Correct.
So I'm going to show you what has been previously marked as Exhibit RD. It is our policy, our school board policy 0809 that applies to teachers, and the ethics and professional conduct that they must have that we apply to all of our employees. Do you see that?
I do.
And was there anything about that particular policy that you found Mr. Johnson's the finding by the grand jury of Mr. Johnson's inconsistent testimony that you thought violated that policy?
I did, and give me 1 second. So within that policy and the Code of Ethics of the education profession in Florida, B, subsection 2, in that second sentence, the educator will therefore strive for professional growth and will seek to exercise the best professional judgment and integrity. And then in section 3, aware of the importance of maintaining the respect and confidence of one's colleagues, of students, of parents, and of other members of the community, the educator strives to achieve and sustain the highest degree of ethical conduct.
Do you believe that Mr. Johnson, in his testimony before the grand jury, violated those provisions?
I do.
I don't have any other questions. Thank you.
Chairman, if I may, once again, we're conducting this hearing, and we're sitting as hearing officers or judges, and to not have these exhibits in front of us as they're presented as evidence is very disturbing. Do we have any idea, or can we find out when we might have the exhibits that they're referring to that are highly technical to actually be in front of the folks who are supposed to be reviewing them?
I understand, Mr. Destin, the issue, and I would just say that I have had the opportunity to review those documents, and I think that the board members may have received those earlier, but I understand what you're saying. I think, Mr. McInnes, that Ms. Crawford has gone to make those copies, but given the fact that there were multiple introductions of items, that it's going to take quite some time to do that. So, Mr. Destin, are you proposing that we go into recess to allow time for that to occur?
That's exactly what I'm proposing.
All right, so board members, I'm not disinclined to grant the recess. So at this juncture, Mr. McInnes, I'm going to declare a recess, and hopefully Ms. Crawford can bring those documents back to us as soon as she can, as fast as the copy machine will run them off. So at this time, we'll declare recess, and I'd say that folks just need to stand by, because as soon as she brings those documents, we're going to get this hearing restarted. So we're in recess at this time. Either stayed or we're all back at this point. We now have the copies, and thank you, Ms. Crawford, for going and making those copies. I know there were quite a few pages here. And colleagues, I would just say, particularly for our newest members, that these documents will come in helpful. Mr. Destin's exactly right, particularly when we have to, and our lawyer will lead us through this, when we have to identify findings of fact. So thank you, Mr. Destin, for your suggestion.
Thank you, Chairman.
All right, so we are back in session at this time, and so I think, Mr. Hardy, we were at your opportunity to speak, sir.
Thank you.
Good morning, Mr. Chambers. We hadn't met. I'm Ryan Hardy. I got a quick question for you. What did you teach?
Language arts.
So did I. Taught it for about 4 years. Always nice to meet a fellow English teacher.
Yes, sir.
What I used to do in my class was I would have kids define words. I was big into that. I wanted these kids to have vocabulary. So I'm going to ask you a couple words. I want you to define those for me to the best of your ability.
Okay.
The first one's veracity. What do you think that means?
I might need a dictionary.
You wrote it in your letter, so I'm assuming you know what it means because you put it in the letter. You don't know? It's okay if you don't know. Just tell us you don't know. Not trying to embarrass you.
Thinking for a second. So the veracity of a situation, the depth of a situation.
Okay. I think it means truthful, but that's fine. What do you think evasive means?
Maybe going out of your way to not necessarily say the right answer.
What do you think the word inconsistent means? We've heard that a lot. What do you think inconsistent means?
Maybe giving varying statements, maybe saying a statement one way, then making a statement another way.
Okay. What do you think contradictory means?
Two conflicting statements.
Does inconsistent and contradictory mean the same thing? In your opinion? Or could they be different?
Just depending on context.
So they don't mean the same thing, is that what you're saying?
I probably would need to put it in context.
Do they mean the same thing or not? Yes or no?
I think I'll repeat myself. I probably would need to put it in context.
Just answer the question. It ain't hard.
I don't object. I think Mr. Chambers has answered the question. It depends on context.
I think so too. Sustained.
What's the word evident mean?
One definition of that would be it's evident, it's clear.
When you hear the term just cause, what does that make you think?
Just cause in terms of legal definition, there are certain things within the just cause definition that would give an employer the right to terminate.
All right, you wrote a termination letter in this case. I think you got it as RC. You have a copy in front of you?
Yes, sir.
You wrote, if we'll go to the second paragraph.
Mr. Hardy, let me let the board know, this also would be PB.
Yes. For clarity's purposes, do I need to use P or R? Does it
If you'll
really?
use the P references.
Let me grab my cheat sheet.
Okay, all right.
And what helped us, Mr. Hardy, is you identified it also.
If we'll look at PB, which is Mr. Chambers' recommendation letter to terminate Andy Johnson. All those words we just talked about you used in there. Second paragraph, you use the word veracity of his testimony. What do you mean?
I think that question was already asked.
Okay. What date did you write this letter on?
In terms of what date I wrote the letter on?
Yes.
Probably have to go back and talk with my HR folks.
Okay. So just clarify, you don't know.
In terms of the exact date the letter was written, no.
Okay. Did you talk to Andy Johnson before you wrote the letter?
I did.
What'd you talk to him about?
I talked to him about my concern with the grand jury report and let him know that I would be making a recommendation to terminate him.
Did you, before you wrote the letter, you talked to him?
Correct.
So you bring him into your office and you hand him the letter and then you talk to him?
I'm trying to think back to that moment.
I understand. Sometimes it's hard to remember in these situations.
No, I think you are correct. I think I spoke with him about the situation, and then I think I gave him a letter. I did give him a letter, let him know what was going to happen.
Did you at any point say, hey, Andy, what's the deal with this? Tell me what happened.
I did not.
Did you, and I'm talking about in that meeting, but even before that, months before, any time before, did you ever say, hey, Andy, what, because you guys are friends, Andy, what's the deal here?
I did not.
So you don't know anything outside of that report, that paragraph on the grand jury report, is that right?
That is correct. That's what I went by.
Okay. When did you read the grand jury report?
For the first time?
Yes.
Couldn't tell you an exact date. Probably somewhere in the, I couldn't tell you an exact date, somewhere late in the 2018 year.
What was your position in the school district at the time you would have read, around that time?
Assistant Superintendent of Curriculum Instruction and HR.
And Ms. Jackson was the superintendent?
Yes, sir.
And did you go to Ms. Jackson and say, you know, I read this grand jury report, I'm really concerned about what's going on with Andy Johnson?
I did not.
Did you ever go to anybody and say anything like that?
About Mr. Johnson?
Yes.
No, sir.
In your letter, your termination letter that we referenced earlier, you used the words, as we talked earlier, contradictory, veracity, evasive. Are those words in the grand jury report?
No.
Okay. And am I correct that the real criticism, or the report, and I guess the criticism of Mr. Johnson in the grand jury reports, he couldn't remember the answer to questions, is that right? He couldn't remember things?
That is not the only reason, no.
What's the reason?
I think if in the grand jury report, if the grand jury report ended at answered, frequently answered that he could not remember, if that was the end of the statement, we probably wouldn't be here today. It went on to say that he also gave answers that were inconsistent with previous statements. While we do not find his behavior before the grand jury criminal, we do find it concerning and worthy of note in this report.
What were the other statements he was inconsistent with? Were they his?
I think you know the answer to that question.
I asked you though.
I don't know all the particulars. I don't think any of us
So
do.
were they your statements that he was inconsistent with?
I couldn't tell you that.
Were they mine?
I couldn't tell you that.
We don't know what they were inconsistent with, do we?
I couldn't answer that.
So a lot of there was a word liar thrown around up here earlier. You don't know if Mr. Johnson lied or not, do you?
I just know in a grand jury where there were several witnesses, Mr. Johnson was one of them, and in here it says that he gave answers that were inconsistent with previous statements.
That's not the question I asked. Do you know if he lied or not?
All I can go by is what's in this grand jury report.
Yes or no? Do you know if he lied or not?
I'm not trying to be argumentative.
It's yes, no, or I don't know. There's no other answer.
So to that specific question, I'd say no, but I'd just go back to the grand jury report.
You think Mr. Johnson ought to be fired because he can't remember things?
If it was just based on not remembering, no.
Because you had a deposition a few weeks ago, didn't you?
More than a few weeks ago, but yes, sir.
Month ago, whatever, in this past year.
Correct.
And they raised your right hand, you swore to tell the truth, all of that, right?
Absolutely.
And any idea how many times you couldn't remember something?
There were a few times, or a number of times.
If I said it was 30, would you believe that?
If you counted that and it was 30, then I would believe it.
Did you always say, I can't remember?
I don't have that in front of me.
Might you have said, I don't recall, I'm not sure, I can't speak to that?
I could have.
Are those consistent?
Is it consistent to say I don't remember, I don't recall? I think that's consistent.
All right. In the school board policies and in your letter, You mentioned district policy, and we're going down to paragraph 3. District policy 0911, and then we're at school board policy 0809. Is a district policy and a school board policy the same thing?
Yes, sir.
So you would agree to me, you could be a little inconsistent with what you're writing down.
I guess if district and school,
You would agree that's an inconsistent statement.
in the context of a letter, I guess it could be.
So since you agree to that, you've given inconsistent testimony, haven't you?
Okay.
And you have not remembered things, correct?
I have.
So you've done the same thing Mr. Johnson was accused of.
Of course, I'm not sitting in front of a grand jury where a student was abused, a teacher went to
Not the
prison for
question.
7 years, 3 administrators were arrested and are no longer with us, and the superintendent is no longer with us.
So this proceeding's not important. Is that what you just said?
That's very important.
Okay. So you did the same thing Mr. Johnson did.
Okay.
So when's somebody coming for you?
So I have a question. Do we have a copy of the deposition that council's referring to?
Yes, sir.
Was that given out as an exhibit?
Yes, sir.
Okay.
To us.
Not to us, though.
Well, that's what I was saying. I didn't copy all of this multiple times. It's here.
Well, I see it. It's like it's about, what,
It's
100 pages, 200
181
pages?
pages.
I was close, 200, huh?
You can go make them if
It
you
takes a
want.
while to get through it.
Had a lot of paper.
It takes a while to get through it. I've made 3 copies.
Okay. All right, then. You've got it that we could look at if we chose to.
Yes, sir.
All right, I'm sorry to interrupt, Mr. Hardy.
Oh, you're fine. You're fine. If I could have just a second. I'm going to ask a couple more questions, and then I'm going to be done. When did you find out you were going to be the superintendent?
January 10th,
What day of the week was that on?
a Thursday.
How'd you find out?
The governor called me.
Had you had any talks with anybody before that?
The governor,
When did you talk to him?
January 9th.
Was that be a Wednesday?
It would be.
Where and how was that communication?
Got a call from the governor's office that asked me to meet him, and I met him in Panama City.
What time of the day did you meet him at in Panama City?
I think about noon.
Okay. Anybody with him when you met with him?
Just him.
Nobody else?
There were people who came with him, but in terms of inside where he met with me, just him.
And no discussions with anybody else prior to that call from the governor in that meeting? You didn't talk about becoming a superintendent with anybody else?
No, absolutely not.
Okay. I don't have any more questions.
A couple follow-up, Mr. Chambers. Now that the vocabulary test is over, do you think school board and district are synonymous?
I do.
I mean, do we frequently refer to ourselves as a school board and then also as the Okaloosa County School District?
We do.
Do you think those are inconsistent statements?
I don't.
Do you think that is what the grand jury took particular note of, was the fact that Mr. Johnson was misstating district versus policy?
any kind of
speculation about
what the grand jury might have thought.
I don't have any other questions.
He has no idea.
All right, so we're through with this witness unless board members have questions. All right, thank you, Mr. Chambers.
Mr. Larkin, further witnesses?
We have no other witnesses.
Any other evidence you want to submit?
All this evidence, I think, has already been stipulated.
Okay. It'd be appropriate, Mr. Hardy, to present his case.
Could I have about a 5-minute recess real quick?
Absolutely.
Thank you.
We're in recess at this time for 5 minutes. We're all back. Miss Mary, when you're ready, let me know. You ready? All right. All right, so we'll go back in to session at this time. And Mr. McInnes, we just finished with the witnesses, and I believe that Mr. Hardy may have something else. Is that correct?
We finished with Mr. Larkin's witnesses.
Right.
Now it's Mr. Hardy's turn to present their case.
That's right. All right,
And I'm
Mr.
gonna,
Hardy.
At this time, call William Andrew Johnson. All right, could you please state your name for the record?
Andy Johnson.
William Andrew, but everybody calls you, we've referred to you as Andy all day. That's the only thing I've ever known.
Yes, sir.
What date were you terminated from the school district?
I'm going to have to say, I don't remember, but it was in late January. There was a board meeting, and I believe they had final action over in February.
What was your position in the school district before you were terminated? What was your position?
I was a program director for safety, health, physical education. Worked with school resource officers as a liaison there.
And when we think back to the time of the grand jury report, what was your position with the school district?
I was a specialist at that time.
And for some of us that don't know, what's that mean?
Well, I still had pretty much the same responsibilities. Over the summer, the state passed some legislation that required strengthening up safety policies with the addition of personnel or a person that would be a school district safety officer. And with the growth of that department after renewing my contract, the board supported promotion to director.
Gotcha.
Program director.
How long have you been in the school system?
I started back in 1976 and worked until 2007 when I retired, and then worked with a daycare early learning center with Holt Academy Child Care Center for about 5 years. Ms. Jackson was elected superintendent and had the position that I held until I've been released.
I've asked you some fluff questions, but let's just cut through them. Did you lie to the grand jury?
No, sir. No, sir.
Why do you think they wrote what they wrote?
Because it was the truth. I did not remember. They asked questions about things that had happened 9 months, just like he said, and I am saying now. Give me notes, give me something to look at so that I can have some recall. I'm asked questions, I have to say I don't remember. I'm not going to tell a lie. If I don't remember, I don't tell a lie. And with regard to conflicting statements, they obviously heard something that was inconsistent. They wouldn't have written it if they had not. But I also know that there are times that you can give conflicting or inconsistent information, and they're accurate and they're true. I worked with Jeff McInnes when Office of Civil Rights or when Southern Poverty Law Center has called into question data that we've submitted about out-of-school suspensions. And they would want to know, why is this inconsistent? And they may have been looking at a report that had days of suspension. Well, we may have submitted a report that had the number of students that were suspended or the days that were suspended. You can say things that are the truth that may sound inconsistent, but it's worth giving someone an opportunity to explain what appears to be an inconsistency. If you can get a copy of that grand jury testimony, you'll find no one ever asked me the question, Mr. Johnson, earlier you said this, and now you're saying that. Which way is it, this way or that way? The truth is, I went to Assistant State's Attorney Bill Bishop, who questioned me before the grand jury.
Was this after the grand jury?
It was after the grand jury. They had written a report. I read what you read. I read that. I get where you can see that. I went to him and said, what is it? I want to get on the same page. I said, I said I didn't remember because, truthfully, I didn't remember. Not going to sit there and make up a lie just so I can make someone feel happy. Okay? I didn't remember. That's the truth, not a lie. And so I asked Bill Bishop, I said, what were the conflicting or inconsistent statements that I made? And he said to me, and I'm going to have to paraphrase, Mr. Johnson, that's the grand jury's report. That's not mine. And I asked again. I said, I just want to know what I said that was inconsistent in my mind so that I could resolve how did I lead people to think one thing and another thing. Okay? And he again reiterated, that's the grand jury's report. That's not mine. To this day, sir, I don't know what I said that was inconsistent or that conflicted. And that is the truth.
Thank you.
And my evasive nature, I was evasive to them as evasive as I am to you right now.
Thank you. I don't have any further questions.
I wasn't. I'm
Mr.
sorry.
Johnson, Andy?
Yes, sir. I apologize for my emotion.
No need to apologize, sir. I understand. But you kept saying particular interchangeable words, and I just want to make sure that it's clear. Conflicting is the same as inconsistent, right?
I've already heard that vocabulary quiz go on one time, and like Mr. Chambers, I think it depends on the context.
Okay. But those were your words and the direct testimony that you could understand that the grand jury found that something you said was inconsistent or conflicting. Isn't that right?
Yeah, it didn't say I lied,
Okay.
did it?
Conflicting would mean that it's not the same, that they're different, right? That they conflict.
Just like out-of-school
That they're
suspension
opposite.
days are different from the number of students
When
that were suspended.
when something-
I would love to have had the opportunity to explain or to have been asked, can you explain the difference between these two statements? I didn't. I don't know what the statements were, sir.
Fair enough. I guess only the grand jury does.
Yes, sir.
But, so, how long have you been employed with the district? Since '76, you said?
I started in '76, retired in 2007, came back in 2012.
Do you know Mary Beth Jackson?
Yes,
How well do you know her?
very well.
Would you consider yourself friends with her?
Yeah, I wouldn't lie for her, though.
Well, let me ask you about that, because you knew going into this grand jury what it was about, right? You knew before you testified what they were inquiring, why they wanted to talk with you.
They
didn't
wanted
you?
to talk to me about an email that was sent to me.
And that you sent to her, right?
To who?
To Miss Jackson.
I copied it to Miss Jackson. I sent it to Stacy Smith, the Director of Personnel.
And you copied it to Miss Jackson, right?
Yes.
And in fact,
because
those are
the
exhibits in the front of
body
us.
of that email indicates she gave me a directive to send the email to Stacy.
Right. And so now you're getting called in a criminal matter to talk to you about what Miss Jackson knew and when she knew it, right?
Right.
And in that context is where you could not remember and you were inconsistent with your prior testimony.
No, sir,
Prior
you're
statement.
putting a spin on some things you just really don't understand. Can I have an opportunity to explain?
Sure.
All right. Prior to the grand jury testimony, there was a meeting in the office of Bill Bishop, Assistant State's Attorney. He took a sworn statement from me, okay? That sworn statement dealt with, in large part, what did I do? What was my responsibilities? So on and so forth. But he asked me, he said, now, back in May, August, it was several months earlier, he said, did you receive a phone call from Major Arnold Brown? And I said, no, I don't remember. Not in front of the grand jury, in his office, giving a sworn statement. I said, no, I don't remember. You don't remember getting a phone call from Major Brown in 7 months earlier? I said, no, sir, I don't. He said, Major Brown was trying to get up with Superintendent Jackson and needed your assistance, was asking for you to help, get in touch with her. You don't remember that? I said, I really don't. Do you remember Major Brown sending you an email? No, I don't. You don't remember this email? No, sir, I don't. I don't remember. It's obvious he sent it to me. There it is. Then he said, do you remember sending an email to Stacy Smith? No, sir. No, I don't. You don't remember sending an email to Stacy Smith? No, sir. Slides the email to you. You don't remember sending this email to Ms. Smith? No, sir, I don't. But it's obvious that I did. There it is. The nature of those emails was a human resources personnel issue. It was not a student discipline issue. And as you look on those emails, we've submitted copies. I've received it about 30 minutes later. I send it to Stacy. There appears to have been a conversation, well, a directive, I wouldn't have called it a discussion or a conversation, from Mrs. Jackson to me. Send this to Stacy. Tell her to call me tomorrow, or I want to talk to her tomorrow. I don't remember what.
All right, I'm going to follow up on just a couple of things.
Well, I'm going to finish.
Okay, go ahead. Go ahead.
So, because you were asking me about my grand jury testimony. So what I'm sharing with you happened before the grand jury testimony. Talk to me about things I didn't remember, okay? I still don't remember getting that email. I've looked at it. I still don't remember sending that email. I've looked at it. Had nothing to do with me. Had nothing to do with my office and my responsibilities. You know, right. So we get in front of the grand jury. He asked me essentially the same questions. And I had to say, truthfully, it's still truthful today, I don't remember getting a phone call from Arnold Brown. I believe Arnold Brown called me. Arnold Brown's a friend of mine. Okay? We work together. He used to send me email every day, or not every day, once a week on what SROs were doing on a weekly basis. So there's no question Arnold Brown called me. If he said he did, he did. Okay? I just don't remember it. I also told the grand jury I didn't remember getting an email from Arnold Brown. I don't. I still to this day don't, but he did. Okay? And then on about sending an email to Stacy Smith, I had to be truthful and say, I still don't remember that, but obviously it occurred. There it is. They had copies of all that information.
Okay, good. So you meet with the state attorney in his office,
Bill Bishop.
and he is asking you about emails that you got from Mr. Brown. And who is Arnold Brown? He's a major with the Okaloosa County Sheriff's Office, right?
That's true.
You is somebody you interact with frequently.
No, I wouldn't say, no, not frequently, but that I have interacted with.
Okay.
Yeah, we've met with.
Fair
Barry
enough.
Venuti back there and I have met with Arnold Brown.
Fair enough. And so you get called into the state attorney's office, and he's asking you questions about emails that you got, that you sent to Miss Jackson and Stacy Smith.
One email that I got, one email that I sent.
Okay. How long before your grand jury testimony is this meeting?
I'm guessing just a few weeks.
Okay, so a few weeks go by, and then you're getting called before the grand jury, right? Did you talk to Miss Jackson between the time you met with Mr. Bishop and the time that you testified at the grand jury?
I talk with Ms. Jackson almost on a daily basis.
Right, did you talk to her about these emails that he asked you about?
Yeah.
Yeah. And I guess,
Mr. Bishop said that there was no limit or restrictions on my testimony.
perfect. And so I guess for the record, we're talking about Petitioner's Exhibit D and Petitioner's Exhibit E, and I think the board should take a look at those. Because the grand jury, because the state attorney was asking you about these two particular emails. Is that right?
Yeah.
And one of them, well, let me ask you, the first one you got was at, what, 407
Right.
on May 18th? What did that concern?
It's titled FYI.
Right, what is the document attached to it?
It's Arden Farley's report that the sheriff's office was going to pursue an investigation on.
Dealing with the child abuse issue going on in the district, right?
It was
Yeah,
It was Arden Farley's report.
exactly. So in May 17th, or May 4th, what's the date? May 18th,
May 18th.
2017 at 4:07, Arden Farley, you get his report dealing with the child abuse issue, right?
Major Brown sent a copy of it to me, and I believe Ms. Jackson.
You believe, but you don't know. Well, what did you do with it?
I sent it to Stacy Smith where it belonged.
And you copied who?
Mrs. Jackson.
And that is what he was asking you about, right? That's what Mr. Bishop wanted to know about, is you get this report and you send it to Stacy and you send it to Ms. Jackson 30 minutes later, right?
Yeah, it says, Stacy, Mrs. Jackson wanted me to share this attachment sent to her today from Major Brown. This says it was sent to her from Major Brown.
Now, attached
okay?
to that report,
With
though-
the Okaloosa County Sheriff's Office. You've asked me a question, I want to answer. Please review the attached file. She wants to discuss with you tomorrow.
Mhm.
So it would appear she told me, send this to Stacy.
Right.
And I did.
So you get a copy of the report on the child abuse issue, you have a conference with Ms. Jackson, and then you send it to Ms. Smith and copy Ms. Jackson. That's the chain of events, right?
Yeah, this demonstrates to Ms. Jackson I did what she told me to do.
Exactly. And so there's a written order of things about who knew what and when. Isn't that right? Who knew about Arden Farley's report and who knew about Ms. Stillion's response, right? Isn't that what you're sending? Isn't that what he wanted to know? Isn't that what Mr. Bishop wanted to know, is whether you remembered those emails?
Yeah, and I did.
You did. And then he slides them in front of you, and then you remember. And that
Wait,
is...
No, excuse me. Back up. What do you mean you remember?
Well, now you remember you sent them.
No, I don't. Were you listening to me when I said
Okay,
even
so
today
sitting
I
here
don't
today, you still
remember?
don't recall sending
Right.
those. Okay, fair
Yeah.
enough. Fair
It's
enough.
obvious I did. It's obvious I did.
Right.
Do I remember? No.
And then 3 weeks goes by, and you're called to the grand jury,
Right.
and the $64 million question, I mean, let's just be square, right? Is who knew what and when? Because now,
He didn't
Now
ask
the state-
that, he didn't ask that
of
question.
course he didn't, because he didn't need to. But the state attorney wanted to know who knew what and when for purposes of liability for this district, right?
And he had given these to the grand jury.
That's right. And then in that testimony is where you didn't answer questions because you couldn't remember, and then you were inconsistent with your previous statements, right? That's what they found, right?
I'm not sure you understand what I'm saying.
I understand
I didn't
completely what
remember
you're saying.
when he showed it to me. I didn't remember it for the grand jury, and I didn't remember. Now, in front of the grand jury, we're looking at these emails on a screen. It's obvious to them, it's obvious to anyone that's in that room, that I did receive and that I did send. I testified, I just didn't remember receiving it, and I didn't remember sending it. And that is the truth today, sir.
Fair enough. Fair enough. I think we all know why you were there, and I'll let your testimony stand.
Yes, sir.
I don't have any more questions.
All right, thank you, Mr. Johnson.
Yes, sir. Do y'all have any questions for me?
have one question, and
No.
we're referring to your testimony in the grand jury report,
Yes,
and we're moving back and forth between inconsistent and conflicting. I'm trying to find where the grand jury used the word conflicting, and I don't have my glasses on.
I think they used the word inconsistent.
They did. Okay, I don't see conflicting there.
No, sir.
Thank you.
Mr. Johnson, I have a question, please. When you got the first email,
Yeah.
okay, and from Mr. Brown, and then you had a conversation with Mrs. Jackson, correct?
That's what this would indicate.
But you don't
Sanchez,
recall that conversation?
I don't remember. I got the email, and it was sent within 30 minutes.
Right.
30, what is that, 4 minutes, something like that. And how long, when he called me, did he call me 10 minutes after the email? Was it, I don't know how much time there was between me getting this and actually sending it. I don't remember. I don't remember being in her office and her giving me the directive that she obviously did, because it's included in that email.
Did you open up the attachment and read what he had sent?
You could find, no ma'am.
So you had no
I-
idea what it was about?
Well, I do now.
No, then, you don't recall knowing anything about? I was just thinking your position, you might have a reaction to that if you got that kind of email.
All right, the attachment, if you look at all right, see the email that he sent, FYI,
Right,
and you see the attachment, it's DOC and just a whole bunch of numbers.
right.
The day that Mr. Bishop reminded me that I had this, I went back to my office to get a copy of Arden Farley's report to read it for the first time that I read his report. I had told people on a number of occasions, I'd love to see that report, not knowing, or not remembering, whatever the right word, not remembering that I actually had one in my email files. So,
Did you ever read that report?
yeah, after meeting with Mr. Bishop, I read the report.
Not until then. So when you got it, you weren't curious about what the report was about?
Yeah, that's what I'm saying. When Mr. Bishop reminded me that, hey, you've got this email, I went back, looked in my inbox file, found this email, and opened it up and printed a copy of the attachment so I could read it. That's the first time I read his report.
So it would have been typical in your position to receive these kinds of reports?
No,
That's-
ma'am. This is the only time that...
So why do you think this one you got?
According to Mr. Bishop,
Right.
Major Brown was trying to get some information to Mrs. Jackson and wanted to...
And he couldn't email her?
Apparently he wanted to discuss it with her maybe that day. It's my understanding he did email it to her. And according to Mr. Bishop, he was trying to get up with her.
So he did not make a phone call to you to get up with her and say, I can't get Mrs. Jackson, can you help me?
That's what, I don't remember that phone call. That's what Mr. Bishop asked me, do you remember Mr. Brown making a phone call to you, trying to get your assistance to get up with Mrs. Jackson? I didn't remember it. But Major Brown said that he did, and I believe he did.
So Major Brown could not get Mrs. Jackson, but when you made a phone call, she immediately talked with you evidently.
Her office was right down the hall. It was like 3 doors down the hall from me.
Right.
And I'm looking at this. The time you can see is he sent the email after 4.
Right.
It may have been that the secretaries that were in her office, if there were any in her office at that time, were just not picking up the phone.
Okay.
And my suspicion is I went down to her and said, hey, did you know Major Brown's trying to get up with you? Maybe I said he's sent you an email. I don't recall. But I know that after receiving the email at 4:07, then at 4:39, I passed this information to where it needed to go. It was a personnel matter. It needed to go to Human Resources. And I sent it to Stacy Smith.
So I wonder why Mrs. Jackson didn't send it to Ms. Smith. Did you have any discussion or any recollection of that?
No.
I'm just trying to understand why you were, quote, the middle guy here,
Yeah, I don't know.
between
I wish I did.
that and,
Yeah.
okay, thank you.
Well, Andy, the only thing I would ask, and I will not put words in your mouth, but maybe other than remembering, because that's been something that you've said that you couldn't remember. Is there anything now in retrospect that when you look back at all of this that maybe you wish you had done differently or you would do differently today? Receiving that report and that communication?
Wish that I could remember it.
Okay, yeah.
One of the things I say, Dr. White, to people that I train and that I work with is don't take a monkey on your shoulders that belongs on somebody else's. So when someone comes in here with a monkey, make sure they walk out with that monkey on their shoulder. And all I can think of is that I was practicing what I preach, and that this was a matter that I didn't need to, it was not my responsibility, you know? Why did I want to get involved in something? I didn't open up, like I say, I didn't open up this attachment, to my knowledge, until after speaking with Mr. Bishop, and Mr. Bishop saying, hey, you got a copy of Arden Farley's report in your emails, okay? I just don't, it wasn't a matter for me. It wasn't my business. It was personnel and human resources. The superintendent, it appears, spoke with me and said, send this to Stacy.
But Major Brown, he must have thought it was your business. I mean, I'm
Well,
assuming.
according to Mr. Bishop,
Mhm.
Mr. Bishop called me because he couldn't get up with Miss Jackson.
Right.
That's what Mr. Bishop has
Right.
had
Okay.
shared with me. He was trying to get up with Miss Jackson.
Mhm.
Couldn't get up with her. Could I help him?
Mhm.
And I'm just trying to put a
Because he sent you a
together.
copy of the report to give, I assume, to Miss Jackson and Miss
I don't-
Smith?
I don't know why he sent it, Dr. White. I don't know why he sent it to me, if he sent it to Miss Jackson. But he did, okay?
I see.
It's obvious, but, you know, I can't explain why people do what they do. I'm just telling you, I can't remember
Sure, I understand.
this part of it. And that's the truth. Do you feel I'm being evasive?
I don't,
You don't?
Andy.
I'm
No.
not.
I don't feel that way.
Okay.
I just wondered if you felt like now that you wish that you had read the report. And then the follow-up question would be, had you read it, what would you have done?
Well, okay, that's a good, this was in the report, this was, as I reflect, was in the hands of the sheriff's office.
Mhm.
And the sheriff's office was already investigating. I would have given it, it appeared the superintendent already knew about it, and, or had a copy of this, and my part was passing along to the
Stacy?
Director of Human
Right.
Resources.
Right.
I think the evidence is I did what I was supposed to do, you know,
You forwarded.
yeah.
Okay. Anything else, Mr.
One other
Dixon?
question about the nature of your employment during this time period. You were under a contract,
Yes, sir.
and your contract would terminate when?
At the end of the year in June, the end of June.
So that would be this coming June, or last? When exactly would it?
Okay, when this was happening, that would have been last June.
Yeah.
Yes, sir.
Okay, but you were under contract with the district until this coming June? You were terminated in January or somewhere
That's right.
thereabouts.
Yes.
So the contract you were under then, when would it have terminated?
Oh, yeah, my contract would terminate the end of this June.
That's right. Thank you.
Mr. Brown?
I just have one question regarding emails. Is it safe to say that in your capacity that the majority of your emails have attachments to them?
A good portion of them, yes, sir, have
Okay.
attachments to them.
Okay, is it safe to say that you would open those attachments due to the nature of usually what you were dealing with student issues?
If it's related to, yeah, something that's in my field, I would open it. There's oftentimes, the word safety is broad-based.
Right.
There's safety stuff that would come up to me about buses, and I would send to Jay McGinnis. There's safety stuff that comes about technology, and I would send it to Steve Horton without looking at all that stuff. Again, don't want to get someone else's money.
Right.
Safety stuff that comes about maintenance and locks and things like that I would send to Mr.
But
Kuchararkis.
going back to my original question, is it safe to say the majority of your emails have attachments to them?
A good portion of them do.
Thank you.
I would just say, yeah, a lot of
Okay,
them.
thank you.
Yeah, I got one more thing. But I'm trying to get it straight why you were getting this email. So it was pretty common that you would get an email from Major Brown, right? Didn't you say about once a week?
Not like this. This was a one of a kind. The person in my position receives weekly what are called end of shift or end of week reports from school resource officers, and there was a period, no longer, as Major Jordan has assumed other responsibilities, but there was a time when Major Jordan sent to me and a few others in the district a weekly report. Every week I'd get an email from him with an attachment on what SROs had been doing in the different schools.
Okay, so I'm wondering, you get this email and it has an attachment, and basically you're thinking it's only because he's having difficulty getting to the superintendent.
It belongs to her.
Okay, of all the people in her staff, you had Mr. Chambers and other people, I'm just wondering why he was coming through you, do you think, to try to get her attention?
He may have known that our offices were the proximity of our offices, and I could step right. Again, it's typical for me to kind of work a little bit late, and I'm late in the office. I probably obviously picked up the phone. He was calling, or may have called me on my cell phone. I don't know, but he was having trouble getting up with Mrs. Jackson. Wanted to know if I could help, and apparently I was able to assist.
But wouldn't you think that if he had made the attachment, that he wanted you to see it?
But it didn't say. It just says FYI in the email.
Okay, but there was an attachment, right?
Yeah. See the email.
I do.
Okay. See, all right. The email simply says FYI, and then there's a bunch of numbers. It doesn't say Arden Farley's report or anything like that.
No, but it says FYI for your information. So he's assuming that you should know this, wouldn't you think?
I don't remember the email. I don't.
I'm just saying, if I got an email that said FYI, I would think someone wants me to know this.
Yeah.
Okay, and so, but evidently, and I know you say you're not remembering, but obviously, by your actions, you didn't think it was that important to open it up
Yeah,
at
right.
that
And
time.
again, yes, ma'am. I preface it with the fact that I was told that he was trying to, I knew, apparently, that he was trying to get this to Miss Jackson. And it wasn't for me, it was for Miss Jackson.
Okay,
And again, if I had opened it up, what I would have seen is something that, this doesn't belong to me. It belongs to the superintendent or to human resources. And that's where it did go, if I had opened it up.
well, he could have sent it directly to Human Resources.
Yes, ma'am.
Right, okay. Thank you.
One further question. Mr. Johnson, do you have any authority to take action on any of the contents of that Arden Farley's report?
No, sir. No, that's a personnel matter. Right.
Well, that's the question I had. You opened it up and read it, what action could you have taken
I would-
other than send it on up the line?
That's exactly what I would have done. Yes, sir.
Thank you.
And I would just offer that that's a very, very broad question that might, in light of what that report says, transcend some of those boundaries that we're talking about.
And I would agree if there was an avenue to take action on the transcending nature of it.
I think there probably might have been.
Yeah.
All right, any other questions, board members? Mr. Board Attorney?
Mr. Hardy, any other witnesses?
I don't have any more witnesses.
Okay. Any other evidence to submit?
It's all been submitted and stipulated to.
It'd now be appropriate, Mr. Chairman, to either allow them a quick break to prepare for closing, because that would be the next thing they can make closing arguments.
I think that I'm hearing concurrence with taking a break. All right, so we'll recess for, what, 10 minutes? Is that good? 10 minutes. Reconvene this hearing, and so at this juncture, Mr. McInnes, I'll turn it over to you for closing remarks.
Yes, sir. At this time, it would be appropriate to allow the attorneys to make their closing statements, and Mr. Larkin would go first to make his closing statement.
I guess just a procedural matter before I begin, you have been given a couple of emails today, and they refer to attachments, and this is the first time that I appreciated that the attachments were not attached to the emails. And if for the sake of completeness, I understand my opposing counsel is going to object, but I would suggest you should have the attachments so that you would know what the emails are referring to, and it might help us all connect the dots a little better. But I understand there's an objection, so I'll allow him to make that.
Is there an objection? Objection, Mr. Hardy?
You guys have all read that report. You can have the attachment. I'm not concerned about that.
Thank you.
Good.
So are you going to give those to us now, Mr. Larkin?
Yes, sir.
All right.
This is one. Pass it that way.
So will we be labeling these as additional respondent exhibits?
They could be your additional respondent exhibits, or they could just be simply attached to the emails that have already been offered. This, for completeness, I think it's important.
Here you go. Tim, coming your way, man. Thank you.
I think, Mr. Chairman, to keep the record straight, because we've already labeled other
Right.
exhibits, I think that we should add these then to the list of respondents' exhibits.
All right.
And
Yeah,
so-
number?
Let's see.
Yeah. RE, I think is the last one. Is that right?
The email that just says on it FYI,
Right.
dated May 18, 2017, that will become RF. And the email dated May 18, 2017, that went to Ms. Smith will become RG.
All right, so we got one that came your way.
I'm sorry, yeah.
This is coming this way. Thank you. There you go, Dr. Kelly.
And further, for the record, Mr. Chairman, then, as the attorneys have stated no objection, would you please receive exhibits RF and RG for the record?
Yes, sir. Sir, received. All right, so, Mr. Larkin, go ahead.
Thank you, Mr. Chairman, members of the board. Appreciate the opportunity to provide this summation. You know, I stood up here a couple hours ago telling you why we did what we did, why Mr. Johnson was terminated. And it's because of the grand jury testimony, but now that we have had the privilege, the opportunity of listening to Mr. Johnson and reviewing these exhibits, I'd like to connect some dots so that we can all sort of have a context about what went down and when it went down and why this grand jury report is so pointed. These emails that we have referred to, that were the subject of bringing Mr. Johnson to the state attorney's office, now have their attachments, so you could see exactly what he was getting and when he got it. Make no mistake, nobody had been arrested at this point in time. Nobody. And I think we all know But the $64 million question in this whole situation was who knew what and when. Who knew what and when did they know it? And you can look at these attachments and they're pretty clear about what they are. And I would suggest, Mr. Destin, that these attachments transcend whatever he thinks his job duties are. They definitely do. Now, he would have you believe, and he's testified to it, that he was just a random guy getting a random email from the major of the Okaloosa County Sheriff's Department. Just, hey, can you get a hold of the superintendent for me and get these documents to her? I didn't even know what I was doing. I don't know why I was involved. No idea. Just a pass through. That's what his testimony was. May 18th of 2017, he gets these two documents, and they are very important. They are everything. Arden Farley's report and the Stillion's response. Nobody's been arrested then. And then he has a conversation with Miss Jackson. What they talk about, I don't remember. Just I got these things, these random documents. I'm just sending them to you. And then he gets called in to the state attorney's office. And he gets asked about them. Don't recall, don't remember, nothing. Can't remember any of it. Don't even know why I was involved. Well, I'll tell you why you're involved. Because if you read the grand jury report, right, it says his areas of responsibility are primarily in safety, athletics, and discipline, as well as crisis management. To some extent, he acts as a liaison between law enforcement and the school district. Well, that's why he's involved. Major Brown is a major in our Okaloosa County Sheriff's Office. He is the liaison to the county. He's not a random guy simply getting a report, and he doesn't even know why. Doesn't open it? Nothing? Really? Okay, I think that's the same issue that Mr. Bishop had with him when he calls him in. Nobody had been arrested then. Nobody had been arrested at this point. People started getting arrested. He gets called in, gives some testimony, don't recall, don't remember any of it. Sitting here today, don't remember any of it. 3 weeks later, gets called to the grand jury, gets asked questions. Frequently answered he could not remember, but there's more. There's more. He also gave answers that were inconsistent with previous statements. You're right, it doesn't say conflicting, Mr. Destin. He said it. He used that term, not me. Because you know why? Because they're the same. And let's not beat around it. We're not talking about eggs and scrambled eggs. We're not talking about forgetting about what I had for breakfast. I mean, seriously? Really? This is what we're about? We're going to grand jury and we're trying to parse out whether it was eggs or scrambled eggs. 3 weeks go by between the time he talks to Mr. Bishop about these documents and the time he testifies. And what does he go in and testify to? Inconsistent statements, and he can't remember. Of course. Absolutely. People are going to jail. Heads are rolling. And this is critical. And that's why the grand jury went out of their way to mention it. That's why. This isn't some minor issue. This isn't some trivial matter. This is about a child abuse case in this district that we did not handle properly. And when the criminal attorneys got involved, people began to run. Conveniently can't remember, testified to different things, inconsistent statements, conflicting statements, as he said. That's what went down. And we all know it. And so this is your school district, and that's your employee. And this is your new superintendent, and he comes in and he takes action that should have been taken. But you know what Miss Jackson did? She didn't fire him. You know what she did? She promoted him, gave him a raise. Really? You get this grand jury report saying this guy is not telling the truth. He's evasive. He lacks veracity. I'm saying those words because they are what happened. in a criminal matter involving child abuse. He doesn't get fired. He gets promoted. What do you think the perception of that is? What do you think? Do you think the school district, do you think these citizens are proud of that? You think they're proud of this grand jury report? You think they want to have people employed in this district who have been inconsistent in their testimony to a grand jury about child abuse and who knew what and when? Fair enough. I think you should uphold the recommendation and terminate him. Thank you.
Thank you, Mr. Larkin. Mr. Hardy?
If we go back to the letter that Mr. Chambers wrote, which we got as RC, and we skip down to paragraph 3, first sentence says, "I consider your evasive and contradictory sworn testimony to constitute just cause for your termination." There's not one word in the grand jury report that says evasive. Not remembering and avoiding are two different things. Mr. Johnson told the grand jury he couldn't remember. He told Mr. Bishop he couldn't remember. He told us here today he couldn't remember because he can't. He's telling you the truth. He's not going to make up a story just to make everybody feel good about it. He doesn't remember it. The next word in there he uses is contradictory. Now, that's not inconsistent. Inconsistent means they're a little bit different. Contradictory means they can never be the same. Dark and light, that's contradictory. They can never be the same. You know, we say supper and dinner. That's inconsistent. It can be this. It's not the same word, but it can be. It can be. You heard Mr. Johnson talk about these emails. You heard him say, even if I read the attachment, which I didn't, and I don't remember, I'd have done the same thing because that's what protocol says to do. That's what I'm supposed to do. I'd have sent it to Miss Jackson. I'd have sent it to Stacy Smith. He did what he was tasked to do. That's his job. He's staying in his lane. We got Mr. Chambers. You know, if we're talking about inconsistent testimony and can't remember things, I don't know if his was much else than that. Now, he can always answer the questions his lawyer asks. He always has trouble when somebody else asks him a question. He had trouble in his deposition when Miss Jackson's lawyers asked him questions. 30-something times he can't remember. Not one time, not 0 times when somebody else asked him a question, he remembered everything. He never used that phrase, "I can't recall" or "I don't know." But he did when Miss Jackson, and the same thing today. Just a yes or no question. He can't remember, or he doesn't want to answer the question because he's being evasive. He definitely knows what the word evasive means because that's what he's doing. And you heard we email. Nothing in this termination letter says Mr. Johnson was fired because he sent an email or didn't send an email or anything about an email. It says he gave evasive and contradictory testimony. Nothing in this grand jury report says the word evasive or contradictory. It's not in there. It says he can't remember and he was inconsistent. Inconsistent with what? I don't know. You don't know. Nobody's ever going to know. We don't know. Unless we could round up all the grand jurors and ask them, there's no way we'll ever know. But it doesn't say he lied. They throw the word liar out. That's not in there. It's never in there. Andy Johnson is one thing. I can tell you what he's not. He's not a liar. And everybody in here knows that. Thank you.
Any rebuttal, Mr. Larkin?
No.
Do both sides now fully rest your cases?
We rest.
Yes.
Mr. Chairman, that will close the record of evidence in the matter and now bring it back to the board on the record. As I described earlier, the first thing that the board has to do is based upon the evidence that's been presented, and that evidence now, for your benefit, includes both the live testimony and all of the documents that have been accepted into evidence, the exhibits. You need to determine from all of that what you believe the facts of the matter are. So we have to have you determine a finding of fact. it's based upon the facts as you find them to be that you will then draw a conclusion as to what the law is and whether or not you uphold or do not uphold the termination. So your job is first to start with finding of facts. I have some basic facts that just are regarding the statutes and process we have here, if I might suggest those first,
Yep.
Mr. Chairman.
Perfect, thank you.
One would be that the school board is the constitutional entity authorized to operate, control, and supervise the Okaloosa County School District. The school board's authority to supervise the school district includes the hiring, discipline, and termination of employees within the school district. That would be one proposed fact.
Yes. You need a separate motion on each fact?
Let me just give you these basic facts, and I think you can do them one time.
All right.
Secondly, at all times material to this matter, the petitioner, Mr. Johnson, was employed by the school board as a district program director. Third, by letter dated January 28, 2019, Superintendent Marcus Chambers notified Mr. Johnson of his intent to recommend termination of his employment as an administrator in the school district. Fourth, on January 28, 2019, the school board, at a regularly scheduled meeting, voted to accept the recommendation of the superintendent to terminate petitioner's employment. Fifth, by letter dated January 29, 2019, Ms. Lindsay Maxey, Program Director, Human Resources, notified Mr. Johnson that the school board approved the superintendent's recommendation that he be terminated from his employment with the school district and provided to him an outline of his rights to appeal the decision and request a hearing. And number 6, on February 14, 2019, the petitioner timely filed a petition for administrative hearing to challenge the recommendation and action. I would propose those are base facts regarding the procedural matters here.
Need a motion, board members?
Also move.
Motion by Dr. Kelly. Need a second?
I have a second for discussion. We're adopting all of those
As findings of fact.
okay.
This has nothing to do with your decision
exactly.
or what you're going to conclude.
I'll second that.
All right, very good. Any discussion regarding those omnibus facts? All right, so we need to vote. All in favor, please raise your hand. All opposed? All right, motion carries 5-0. All right, so you have any other facts you'd like to submit at this time, Mr. McInnes, or would you prefer board
No,
members
sir, I
to
think
go
at this
ahead?
point now, the board needs to determine what you've heard from the evidence or what you deem to be relevant
All right.
facts.
Well, I have a couple that I've written up, and then, board members, I'd ask that you certainly jump in. Let me go ahead and propose these. And do we need a separate motion for every finding of fact, Mr. McInnes?
I would think we would, yes, sir.
All right, then. So my first finding of fact in this particular matter is that Marcus Chambers previously served as the Assistant Superintendent of Instruction and Human Resources. I'm looking for a motion.
I think that one's pretty accurate. I'll make that motion.
All right,
I'll
need a
second it.
second. All right, Mr. Bryant seconds. Any discussion? All right, let's vote. All in favor? Motion carries 5-0. Second one is this. On January the 11th, Marcus Chambers was appointed Superintendent of Schools by Governor Ron DeSantis.
So moved.
Motion by Mr. Destin.
I'll second it.
Second by Mrs. Evancheck. Any discussion? Not seeing any, let's vote. All in favor? Motion carries 5-0. And this may run into those that you've already proposed, Mr. McInnes. Please correct me if so. Marcus Chambers, serving as Superintendent of Schools, recommended to the school board the termination of Andy Johnson. That's period. And I think, Mr. McInnes, you more or less identified that one earlier.
We've identified the letter in which that happened, yes.
All right. Okay, so then at that juncture, I'm going to go ahead and strike that one because we've already determined that. Superintendent Marcus Chambers identified school district policies 09-11 and 08-09 as policies that Mr. Johnson was found, what would be a good word for that? in violation of? I think that's in the letter.
It is. So
So,
moved.
need a motion? Motion by Mr. Destin. Need a second.
I'll second it.
Second by Mr. Bryant. Any discussion? Hearing or seeing none, let's vote. All in favor? Motion carries 5-0. I want to make sure, because, and board members, we've heard the equivocation, if you will, but in terms that are used. So I want to make sure that we get this one exactly as the grand jury report says. The grand jury report found that Mr. Johnson gave answers that were inconsistent with previous statements.
I'm afraid that's factual, so I'll make that motion.
Motion by Mr. Destin. Need a second.
So moved. Second.
Second by Mr. Bryant. Any discussion? Seeing none, let's vote. All in favor? Motion carries 5-0. The grand jury found Mr. Johnson's behavior before the grand jury concerning and worthy of note in their report.
I move.
Motion by Ms. Evancheck,
Second.
second by Mr. Bryant. Any discussion? All right, let's vote. All in favor? Motion carries 5-0. Superintendent Chambers found that Mr. Johnson violated the Code of Ethics. I think that's in the letter. I need a motion.
And the code of ethics, by that, the one that's cited in the correspondence.
That's right.
For professional educators.
In the letter,
Florida.
right.
Okay.
I think that's in Mr. Chambers' letter. Did I misread the letter?
Oh, you
No,
read
we're
the
just
letter,
looking
right?
at the,
Okay.
I'm looking at the ethics thing here.
Yeah, but, okay. I based the fact on the letter, that's all.
So you are just stating that
Mr. Chambers
Mr. Chambers found
found
him in.
Mr.
that
Chambers
Mr.
found it,
Johnson
okay.
violated
Okay.
the Code of Ethics.
Okay.
Do I need a motion? Or I'll make it if I have to. You ready, Mr. Bryan? Passing the gavel. I make the motion.
Okay, we have a motion on the floor. Is there a second? Okay, hearing none, that motion fails. I'll pass the gavel back to the Honorable Chairman.
Thank you, Mr. Bryan. Mr. Chambers found that Mr. Johnson violated, well, we've already covered the policy 09. That'll cover it then. We've got that one. Mr. Chambers identified pursuant to Florida statute, section 112-33, that just cause exists for the immediate removal of Mr. Johnson. I think that's the last sentence in the, could say third paragraph in the letter of termination.
Mr. Chairman, if I may, of course, that is in the letter, and Mr. Chambers did find that, or he wouldn't have put it in the letter. And maybe this is a question for the attorney. Since the letter has already been accepted into the record of the proceeding, what is the,
Protocol.
and what is the, what are we accomplishing by citing what the letter says on an individual basis as findings of fact?
Well, the letter is the exhibit to the proceeding. The board has to determine from the letter, elements of the letter that are to be determined to be findings of fact. So the record will have all the exhibits attached to it, but the final order you enter does not have all those exhibits attached to it. So if there are portions of exhibits and evidence that you want recited in your order, then you have to do them through this process.
And could I ask a similar question? I believe I heard it stated earlier today that prior to the letter being exchanged, that Mr. Chambers had consulted with legal advice so that what was in the letter is appropriate as consuming or as defying just cause. So he was assured by legal counsel that this was just cause.
Yes, Mr. Larkin was in consultation with Mr. Chambers in the process of all of that.
Okay, and so then by accepting this, as the chairman is positioning us to say that we are accepting all of that this letter embodies to be legally counseled and appropriate.
And I appreciate that question, and I guess from my limited layman's perspective, counselors, just cause for termination of an administrative contract is a significant hurdle. And I'm saying that it was established in this letter.
Okay.
And that's why, in my opinion, this board voted to uphold this.
Now, of course, the question we have before us today is, we are sitting here as the hearing officer to determine whether or not the charge is substantiated by the evidence.
Mhm.
If we are simply reciting the charges to have them as part of the record, then I would say that's appropriate. If this motion is an attempt to make a judgment on whether or not that the charge has been substantiated by the hearing today, then that's a different question.
And I get that, Mr. Destin, and I didn't hear, but I might have missed any argumentation concerning just cause by the attorneys. And so I'm suggesting that just cause existed for this action, based on this information, based on this letter. That's all.
And I guess that's really what was undermining or underlying my question, in that
That's right.
regrettably, the grand jury report states concerning and worthy of note. I don't for 1 minute think that Mr. Johnson is criminal or tried to behave in a criminal way.
No.
But that statement in the grand jury report concerning and worthy of note, I'm thinking is what was largely behind the consideration of just cause there.
Well, and I would add those, and that's why I'm going through each one of these
I
items.
understand, I appreciate that.
Those policies that were found to be in violation of, and also in terms of the professional code of ethics.
Okay.
So that's how I see the just cause being built for this action.
Let me ask Mr. McGinnis a question. Superintendent supervises all the employees.
Yes, sir.
If he does not have confidence in an employee, he believes that the employee is not doing the job that he expects, is that not ground for termination?
I mean, if an employee is not fulfilling their duties and is not following the directions of the superintendent or their supervisor, then that certainly could be grounds for
Insubordination.
insubordination, which then
Right.
could be grounds for termination.
Okay. How about just an employee that the superintendent feels is not doing the job and to the degree and expertise that they expect?
it would be a decision for the superintendent, but that, I mean, that could be handled in a number of ways. I mean, they could propose corrective action and put them on an improvement plan so that they have a chance to make performance. They could recommend a change of duties, responsibilities. They could non-renew them when the contract rolls back up. I mean, that's something the superintendent would have to determine based upon the level and depth, I guess, of non-performance.
But that was an option, or is an option. And I guess just for my own benefit and the benefit of our newer members, when something like this comes in before us, is our ability just to say yes or no, or is our ability also include a different outcome? In other words, can we make a ruling that determination would be modified, or no?
I think once it gets to this level in the hearing, then the board has ultimate jurisdiction and discretion to give that ruling. I mean, that you uphold it, you don't uphold it. If there were some levels of something involved there, you could adjust those levels as you believe the facts and evidence and the law supports.
But the rejection of such a recommendation would have to be, would not it not, upon a failure to meet just cause?
I think if the board was in a quandary over that kind of issue, the board could then decide to deal with that issue by how you draw your final conclusion and the final actions that you order to be taken.
Well, I guess what I'm saying is from a layman's perspective, I'm concurring with Mr. Destin that when the recommendation is presented to the school board, in my opinion, for it to be rejected by this board, it would have to be a failure to meet just cause. And
Yes, if you were just going to reject the recommendation,
Right.
then you would have to have findings of fact and conclusions of law that determined that in their case, the district did not support just cause. I was also hearing Mr. Destin ask, though, do you have other options in between there? And I'm just simply saying that
Right.
the school board has broad authority in these proceedings.
Okay.
But yes, Dr. White, you're correct. A total rejection would mean that you would find that just cause was not proven.
Anything else? All right.
I have something.
Yeah, yes,
Please,
ma'am.
okay.
There was no action on that last stated
Oh,
proposed
That's all right.
fact, so.
Right, okay. Let's go back to it. Superintendent Chambers found in this letter that Mr. Johnson violated these different things that we've talked about, professional standards, policies, etc., and that just cause exists for his removal. That's in the letter.
so we're just stating as a fact that that's what Mr. Chambers found.
That's what Mr. Chambers' letter says.
Whether we agree with that or not, it doesn't matter.
Well, that'll be another discussion.
With that clarification, I think we can move forward with that motion anyway. So I will make that
Thank you,
motion.
Mr. Destin. Motion by Mr. Destin. Need a second.
I'll second it.
Second by Ms. Evancheck. Any discussion? Any further discussion about that item? All right, let's vote. All in favor? Motion carries 5-0. All right, next fact, and I'll come to you, Ms. Evancheck. I only got two more.
Certainly,
And then
yes, sure.
I'll finish and I'll be done. Mr. Johnson received an email from Major Brown with an investigative report from Arden Farley on May 18th, 2017.
I move.
Motion by Ms. Evancheck,
I'll second.
second by Dr. Kelly. Any discussion? Seeing none, let's vote. All in favor? Motion carries 5-0. Last one. Mr. Johnson forwarded the email to Mrs. Stacy Smith on May 18th, 2017.
I move.
Motion by Ms. Evancheck,
I'll second.
second by Mr. Bryant. Any discussion?
Yes. Should there be a clarification also that Ms. Jackson was carbon copied on that particular?
That's, if you want to add that?
Well, I
Sure.
think we should.
I think that's a
since
good idea.
Yeah.
I accept that as an amendment, if you will, to my motion. So your second still stand, Mr. Dustin?
I think
I'm
Dr.
sorry.
Kelly made the second.
Oh, I'm sorry, Dr. Kelly. You still stand? Okay.
Absolutely.
So any more discussion? That's a good point. I appreciate that, Tim. Okay, all in favor? Let's vote. Motion carries 5-0. Okay, so Ms. Evancheck, I think you had some findings.
No, I have a concern. Can I speak to that now? Or do I have to just stick on finding, on the
Well,
facts?
we're in the phase of the hearing
Okay.
to determine the facts.
Okay.
And then there will be, and obviously, as you're determining facts, you can have any discussions you want to have. We will get to a section where, based upon the facts, you will then discuss what those mean, what your conclusions
Okay.
are.
Does that help?
Okay, I can
Will-
state,
will that-
a fact that I think will cover
Okay.
what I'm talking
All
about.
right, go ahead.
And my fact is that while Superintendent Chamber states he found just cause, there are no other pieces of evidence that show any kind of reprimand or any other disciplinary action against Mr. Johnson in his work. In his position. That it's strictly based on the grand jury report.
Okay, and just a point of clarification, the grand jury report is one of the elements that Mr. Chambers cited, but I think in reviewing that letter,
Okay.
he cited some other items, and that would be policies, and he also cited professional standards of conduct.
But we don't have anything that shows specifically what the action was where he breached that, you know what I'm saying? He didn't say because he was reprimanded on this or that, is what I'm saying. It sounds like it's basically coming from the grand jury.
Well, it was one of them, there's no question. Counselor, I'll have to
Am I off
defer.
on that?
Are you saying that there was no record evidence of any progressive discipline against Mr.
Yes.
Johnson?
Yeah,
in
very
his
well.
employment in general?
Yes.
Okay, I just was trying to clarify that between that and the basis for this discipline, whichever one it is you're trying to say.
Okay, so then the follow-up question for me would be, is that necessary to have just cause in an action because there is no progressive discipline?
No, a termination decision is based upon the facts of the incident. I mean, you could have termination without that. Oftentimes, you see that with termination, so it depends upon the severity of the incident involved.
Okay.
Okay.
So that's your motion.
Yes.
All right, we need a second.
I'll second it.
Second by Mr. Destin. All right, any discussion?
Just for clarification, Mr. McInnes, could you repeat what you're going to put down?
I had written down, while Superintendent Marcus Chambers stated he found just cause for termination, there was no other record evidence of any progressive discipline against Mr. Johnson in his employment.
It's a fact. I think it's a fact. There is no other evidence of progressive discipline that we're aware of. I mean, maybe another matter.
The basis of determination is the grand jury.
All right, okay. But we're not aware, or there is no other discipline that we're aware of. Okay, I don't know what the file says. All right, okay. Anything else, do we?
I think that I would propose a finding of fact. that
Well,
there-
we need to vote.
Oh,
Do we need to
okay,
vote?
yeah.
It's okay.
That one.
On
Yeah.
that one,
So
sorry.
any other
Okay.
discussion on that one? That's all right. Any other discussion on Mrs. Evanchek's motion? Okay. And I think we've confirmed that there's no other progressive discipline in place in the question out there. So, anything else? All right, let's vote. All in favor of the motion? Motion carries 5-0. All right, let me defer back to her. Is there anything else any other findings of fact? Okay, all right. And Mr. Destin, you interjected, so I'll turn to you.
I would just make a finding of fact that the terms evasive and contradictory do not appear in the grand jury report.
Well, that's a fact. Okay. So, as stated in the superintendent's letter.
Right.
So would you accept that as an amendment?
If that's a clarification,
Yeah.
no problem.
That's all it is. All right. Okay. Anything else?
Well, we need a second.
Yeah, got a second. First, motion by you, need a second. So, looking for a second, colleagues.
I'll second.
Second by Dr. Kelly. Any further discussion? All right, let's vote. All in favor? Motion carries 5-0. Anything else?
On findings of fact, that's the only one I had.
Mr. Bryant, you have any?
No, you pretty much
All right, Tim.
hit mine, so.
All right, Mr. Attorney, I'm not hearing any further findings of fact from board members.
So if not, then we would go to the...
Well, is there anything that you, as our attorney,
I mean, the only facts I don't see are whether you determined based upon the evidence, if you determined a fact as to whether or not the superintendent's allegations and charges are accurate. I mean, you haven't given that answer.
That is the key, isn't it?
I think that'll be the motion. Is that correct?
Well, typically, you would conclude your findings of fact with something related to your determination of the evidence, you know, whether that charge factually, did that occur or not occur, what, you know, the violation of the policies, the violation of the code. You haven't said that in here.
All right, so for example, then you need a motion that Mr. Johnson violated the Code of Professional Conduct. Is that right? Is that what you're saying?
If that, I mean, yes, we need the board to determine one way or
For each
the
one
other
of
whether
those.
those are facts or not facts. You can also include that in your conclusions of law, if you want to include that as a conclusion of law, one way or the other.
Well, before we do that, I do have another fact that I'd like to submit to the board for consideration, that Mr. Johnson served as the liaison between the district and law enforcement. So without a motion, I'm prepared to pass the gavel symbolically.
I was waiting for you to say.
Yeah, it's coming your way.
No, I'm going to make a motion that we'll accept your.
Oh, you, okay, so
Because that
Mr.
is-
Bryant,
that is-
Mr. Bryant makes the motion then, need a second?
I'll second.
Second by Dr. Kelly. Any further discussion?
The only question is, I would be a little confused about what the definition of liaison would be.
Well, we've had some,
Point of contact?
well, we've had some equivocation of terms today.
Yes, we have, haven't we?
Well, and I also think, for the record, I believe Mr. Johnson did say he was the liaison, if I'm not mistaken. So,
All right. So, I guess, any other discussion? All right, we need to vote. All in favor? Motion carries 5-0. All right, board members, help me out. So you heard what the attorney said. We need to lay the foundation for the forthcoming motion, whatever that motion might be. Is that right?
Yes, sir, whatever your ultimate decision is going to be. And if you want to end the facts there and move into the conclusions of law, then obviously you can draw a conclusion in that section as to, based
understand.
upon the facts in the law,
Right.
that you find or you don't find.
Well, in my mind, some of the predicate for all that has already been laid in some of the earlier findings of fact. For example, The grand jury report found that Mr. Johnson gave answers that were inconsistent with previous statements. That's already a finding of fact.
Is that, you've stated that in the...
Right.
You've already said that, yeah.
So it may be that you're ready to move on to conclusions of law.
Well, I don't know. Board members, do you have any other findings or thoughts regarding this before we move to, I guess, a motion to uphold or?
No, we need to recite several conclusions of law. Once again, there's some predatory conclusions that will just recite statutes and things like that when you're ready to move to that section.
Okay, and you have those?
I have
at
some
your
of
disposal,
those.
hopefully.
Right. You still have to make this ultimate decision, but there are some
Right. I get
basic
it.
legal standards
All
that
right.
need to be
And we'll
recited.
put those in there. Okay. Anything?
Just for a clarification, Mr. McGinnis, since Mr. Johnson was working under a contract, and I'm reading through the contract, it has a number of provisions, and one of them that it's understood that this contract is not to prevent the termination of the position. What's the difference in a person that's working on a contract and just an employee of the district? I would think a contract can be terminated at the request or the desire of the superintendent. Is that what this contract says? I've not read through the entire thing, but to my mind, there is a difference between a contract and an employee that's not working under a timed contract like this.
Well, in the school district, for the most part, all of your employees are under one form of
The
a
master
contract or another.
right.
There is a master contract for instructional, a master contract for support professionals. Administrative managerial employees are all under annual written contracts. So in essence, all of the employees have a contract of some form or another if they're full-time employees.
So this is not different than those.
No, each one of those contracts then provides for how it can be terminated, how an employee can be disciplined, and that standard is already here as to whether or not there's been just cause proven to terminate this contract.
Okay.
And there's there's all kind of law about this, right? I mean, there's statutory law, there's case law
Correct.
about these contracts. That as lawyers, us being non-lawyers, we struggle with. I know I struggle with. Is that helping you, Mr. Dustin?
Oh, not much.
I know. I'm with you.
Well, Mr. Destin, I mean, I want my answer to you to be complete. And as I understand your question, in regard to an annual written contract for a school district employee, the way in which it can be terminated is for the superintendent to bring charges against the employee for violations of something.
It's just cause.
Bring those to the board considers that at an initial meeting, votes, and then the employee has a right to appeal. And in this case, there was an appeal. And so that comes back to this board. It is ultimately the school board is the only entity that can finally terminate a contract of employment for a district employee in this setting, the managerial administrative employee. And the statute provides that authority rests with the school board in regard to managerial administrative employees. So that's the statutory authority that brings you here today, is that you have the ultimate decision as to whether or not to terminate that contract.
But if Mr. Destin is asking the question, is this particular administrative position a at-will employee, whereby summarily dismissed for, that's...
Well, it appears to say in one section that in this contract is, this contract shall not operate to prevent the discontinuance of a position,
Okay.
which,
Well, first, if an employee is under a written contract, they're not an at-will employee. Because that's typically where there is no written contract,
Right.
and there's a lot more discretion in regard to termination of an at-will employee. That provision, Mr. Destin, that's in there is often discussed and debated. There's some belief that that's talking about discontinuing a position, as if you were going to, because of financial reasons, you were going to have to cut funding or allocations and discontinue a position during the course of contract term. one interpretation of that.
And that does happen.
Yes, sir.
Or I would think even if position was no longer needed or was not performing in the manner that you thought was appropriate, you know, so that's what lawyers are for, right?
Yes, sir.
Anything else?
Yes.
Ms. Bench?
Mhm.
Sure.
I'd like to state as a fact that Mr. Johnson here today still maintains that he does not remember receiving this email from Major Brown nor sending it on. And that from that, it would seem that he was used basically as a conduit to move that information over without him being involved in it.
Can we separate that into two separate motions?
We can.
Okay, so the first motion would be,
That he maintains he does not remember receiving, discussing, or sending on the email from Major Brown.
okay, so that's the motion.
That's my motion.
We need a second.
That, yeah, I'll second that.
All right, Mr. Bryant seconds. Any more discussion? I mean, that's the testimony I've heard. So let's vote. All in favor? Motion carries 5-0. All right,
Okay, the second part then, that would lead to the fact that he was generally was serving as a conduit to move that information to Mrs. Jackson and to Ms. Smith, that he was not involved with the information beyond moving it forward. That's he maintains that.
I will second it just for discussion.
Okay, so motion by Ms. Vancheck and second by Mr. Bryant.
And I would like to just, we talk about vocabulary and all that. I just want to make sure that the finding of fact was the word conduit.
Conduit, yes.
Conduit. Okay, so, but I recall, like I said, I've stated previously that his testimony was that he did say liaison, so I wonder if we should
Okay.
maybe say liaison and that, would that be?
That's
would that be?
that
It's an
might.
amendment, if you accept it.
I accept that, yes. Okay, thank you, Mr. Bryant. So that, it-
Using the word liaison rather than
Is-
conduit is your
yes.
change.
Right.
Mhm.
Well, I mean, for the sake of vocabulary etiquette here, so let's.
Well, we wouldn't want to equivocate.
Right.
okay, that's my motion.
Okay, and so we have a second.
Right.
Mr. Bryant?
Yes,
Help me
yes.
remember. All right, so any more discussion then on that particular item? And I would just say, I think the evidence shows he did exactly that. He sent it to Ms. Smith. Is that right?
Right, and to
Ms.
under
Jackson.
Mrs. Jackson's request,
Right,
yes.
Right, right. Okay, so I'm ready to vote if y'all are. All right, let's vote. All in favor? Motion carries 5-0. Anything else? All right, Mr. McInnes, I guess now would be, as far as I can tell.
Move on to
my
conclusions
colleagues.
of law?
Yes, sir, I think so.
Okay. And I would propose board members as foundational conclusions of law, just for the proceeding. The first would be the School Board of Okaloosa County, Florida, has jurisdiction over the parties and subject matter of this proceeding pursuant to sections 120.569, 120.511, and 1012.336B Florida statutes. The second one would be section 1012.22, subparagraph 1 Florida statutes provides in part that a district school board shall designate positions to be filled, prescribe qualifications for those positions, and provide for the appointment, compensation, promotion, suspension, and dismissal of employees subject to the requirements of Chapter 1012. Third conclusion would be the school board has the authority to suspend or terminate employees pursuant to sections 1012.22(1)(f) and section 1012.336B Florida statutes based upon a recommendation of the superintendent. The next standard would be The standard for termination of employee is just cause pursuant to Section 1012.33 6B Florida statutes upon recommendation of the superintendent.
We need a motion?
You recommended we adopt those in a single motion.
Yes, sir, as conclusions of law.
So moved.
Motion by Mr. Destin,
I'll second.
second by Dr. Kelly. Any discussion? Seeing none, let's vote. All in favor? Motion carries 5-0.
Now, it's for the board to determine, based upon the facts as you have found, the evidence of the hearing, do you conclude, what do you conclude, understanding the authorities you have and the statutory requirements you have to draw now a conclusion as to what those facts tell you in regard to your action?
Let me ask you another question, Mr. McGinnis. Do we have the ability to modify, not the termination, but the termination without pay for the remaining period of the contract, which is approximately 4 months? In other words, can we uphold one and not uphold the other?
I mean, I believe you can uphold a termination if you want to take action to include some type of severance. I think that would be the board's decision if you did that.
Well, that's a possibility, group.
I agree.
Well, unfortunately, we operate based on motions.
Yes, we do.
So, well,
I mean, I guess, could you restate that again, just,
I was asking if we had the opportunity to uphold the termination, but to not support the termination without pay for the remainder of the contract, which was approximately 4 months. In other words, he would get the remainder of his contract, but he would be terminated.
So do we vote on termination and not, and then look at something like that, or do we have to put it in that package to vote on? Do you know what I'm asking?
I mean, I think that would all be part of your final action as to if you're terminating with that condition or terminating with that provision. I mean, that's all, you can do it either
One
way, but it's
motion.
all part of the final action.
so are we at the point then where we're prepared to make a motion to support or reject the superintendent's recommendation?
I think in the
Or revise.
conclusion section, you still need to conclude whether or not, based upon the facts, you believe there is, as a matter of law,
Okay,
just cause
So then it would be stated this way. Based upon the facts, the recommendation is to, I see the attorney
Mr.
standing.
Larkin has
so
a
you know what that means.
comment.
You want to come forward? Go ahead.
If I may, members of the board, in the event that the board is considering some type of severance agreement, as your labor and employment attorney, if we are going to move in that direction, then I would suggest that it be part and parcel of a general release and settlement agreement. If that is in fact what the board desires, I cannot sit there and have the board consider this without
Right.
considering.
Well, let's talk about that. Would that come before a motion or after a motion?
Obviously, that would be up to his counsel, but I would suggest that any severance that is considered be subject to a comprehensive and general release agreement, releasing the district and its employees, board members, and so forth of any and all future liability.
Okay, I understand.
And
Thank you,
let me
Mr.
ask Mr. Larkin a question, and maybe it's a nuance. What I have suggested as a possible alternative is essentially paying a contract and letting the contract be terminated. We have done that in this district in the past. We have paid the contract and sent people home. Is that what you're concerned about? And I understand your concern. You want a release of liability in exchange for that, and that's reasonable. But is there, if you just simply say, we're going to pay your contract, but we don't need your services, you have to roll that into what you're talking about.
Obviously, that's inconsistent with what we have moved here
Presented,
today.
right.
Yes.
Okay, but to the extent that that is what the board desires to do, that is your call. But in the event that that you do proceed in that vein, any monies that the board gives pursuant to the contract, for any reason, whether you call it severance, whether you call it with the contract, I would suggest that it be subject to the parties having a full and general release of all claims. That if we are going to give money, terminate the contract, terminate employment, that be subject to a release agreement, that there be no future liability for either entity concerning his employment.
And that's what you're saying.
Yeah.
Close it out.
I understand that. I see.
Speak it all. Look, all we've ever asked for is just let him finish his contract. That's all he wants. We're not at reinstate him, let him finish his contract, don't renew it at the end. He's got, and it's over.
Right.
So you would be willing to enter into the release of liabilities that Mr. Larkin's referring to?
Reinstate his contract, not terminate him, let him finish his contract out, whether that's at home or whatever. And
That's a
yeah,
little bit different, I'm afraid.
we'd probably do that. Otherwise, we probably wouldn't do that.
And I can't help but add, counsel, here, and for everyone, in my mind, that's a rejection of the superintendent's recommendation.
Well, it's a modification for sure.
Well, the recommendation's on the table. It's been voted on once, and now we're back here again to hear it in some kind of impartial manner. So, now, I would also say, if I understand correctly, this doesn't have, I mean, that's something that can come up in another venue, in another place. Is that correct, Mr. McInnes? Right of appeal?
Well, once you act, then there is a right to appeal, but that goes on to another body. But the
Exactly.
issue there is not going to be this potential, payment or non-payment. Is going to be either you acted within the bounds of the law or you didn't act within the bounds of the law.
Right. But ultimately, that decision would be based upon the remaining length of the contract, right? I mean, that's all that would be
That's correct.
basic of the appeal, anyway. Of course, there'd be other costs.
Are you talking about the length of the contract from now or from when he was let go?
Right.
It's from when he let go.
Right.
Okay, gotcha.
Just so I'm clear on what you're saying, Attorney. So if we paid the remainder of the contract, but did not reinstate Mr. Johnson in his position, that you would not be amenable to that?
It's something Mr. Johnson and I haven't spoke about. That option wasn't on the table. We hadn't talked about it. I would, short answer real quick, tell you no, but I would think we have to talk about it. We haven't talked about it.
Right, of course. Well, look, I'm prepared to make a motion, all right? And so I'll pass the gavel, Mr. Bryant, to you. I make the motion that based on the finding of fact, that this board uphold the recommendation of termination.
Okay, we have a motion on the floor. Is there a second? Okay, seeing no second, that motion fails. I'll pass it back over to the honorable chairperson.
Okay? Somebody else's turn. So if we don't do anything, what happens?
Well, you have to make a ruling.
Well, you see it. Let's hear a motion. Somebody, ante up.
Okay, I would like to move that we go ahead with the termination. However, I do believe that we should honor his contract so that we can end it on June 30th. So we're going to pay out that contract and then sever all relationship with Mr. Johnson as an employee.
And if you propose the payout, it would be contingent upon a general release from
Yes,
the employee.
and general
as to that
release,
payment.
it's done. No, he can make no appeal, no, and no fault to us. We just no longer, he's no longer in our employment, and we've paid him out, so to speak. And he would have to agree to go with what you're saying, that
All right,
agreement.
let me ask this, which is certainly unorthodox, but that's kind of where we are right now. prior to that action, Mr. Chairman, would the board want to, and I don't know if there's votes here for that action.
It looks like it.
If there are, would you be willing to take a brief recess and let the two attorneys discuss the contingency of a proper release to determine whether that's acceptable? That could affect what you do.
That just seems out of order to me.
I'm trying to
I
find.
mean, you used the word unorthodox,
Yes, sir.
but it seems like it's out of order because this hearing was called to either support or reject the recommendation of the superintendent.
I'm not sure that we're restricted by the definition. We're here to judge not just the rejection or the support, but we can modify it, which is what we're attempting to do.
Three votes of the board, I believe, can do that.
I don't know about that. I mean, we need to go back and look at all of the letters and the communications that we've had with these counselors regarding this hearing. And I don't remember seeing anything in there about us modifying the order.
There have been no communications with counsel that described what the board's options were.
Right.
They have described the focus or parameters of the hearing itself in regard to evidence and witnesses and things of that nature. But it's back in the board's hand now to make an ultimate decision as to what you're going to do.
And on that note, I will make a motion directing that.
Wait, I thought I had a motion.
I'll
You do.
substitute
Okay, gotcha.
motion directing the recess to see if the attorneys can agree to that release.
I'll
When are
second
we
that.
going to know that? Today? Right now?
Right now.
You want to do a recess?
15 minutes, 20 minutes. Attorneys, is this even worth discussing? Tell me, and I'll withdraw the motion if it's not.
We're open to anything.
Okay.
But we need 15 minutes. If you want to consult with your client, we can have a conversation in about 1 minute.
A 1 minute recess?
So I think it comes down to whether Mr. Johnson's going to accept that. And if I understand
Here you go, Tim, you
correctly,
do it.
it's
I'll
going
pass
to
the
be a
gavel.
termination. It's going to be a termination, but we're going to honor his contract, which, all right. And that's subject to him agreeing to a release. Now, I just heard his attorney say that that was not what he would accept. So but that he had talked to Mr. Johnson.
I
So
don't have a release. I'm not agreeing to anything unless I'm looking at it.
I don't have one in my wallet.
So it's rejected by the council.
We'd be willing to do it, but I gotta have something to look at.
It will be a general release that he waive any and all claims that he has right now or has had in the past up to the date he signed it against this district, the school board members, current and former, the superintendents, any employee, attorneys, benefit plans, everything. Any claims, whether discrimination, wrongful termination, whatever it is that he may have.
Do you want to, go ahead.
Well, there's no second to the motion yet.
Well, I think they want to
Well-
recess, so he can declare it.
I think we should go ahead and take at least a 10-minute recess.
Yeah, okay.
Call this meeting back into order. If everybody would please take their seats.
Mr. Chairman, if I might, for clarification, at this point, I think that the best move for the board to take is to move forward with your decision based upon the findings of fact and conclusion of law as to whether or not you're going to uphold or not uphold the termination. The parties certainly then, after that decision, separate from this proceeding, can make that decision if they want to propose a severance package or something to waive matters, to not go to appeals. All that kind of stuff can be done separately and outside of this proceeding, which is a better place for that to happen. So I would propose at this point the board needs to make a decision to either uphold or not uphold the termination, and then other matters can be resolved separately from the proceeding.
Okay.
Not saying what they are or what they are not.
Okay. Thank you, Mr. McInnes. So at this time, Mr. McInnes has stated the position. Do we have a motion on the floor to accept Mr. McInnes's recommendation?
Well, I'm not recommending what you do, I'm just recommending that you make a decision one way or the other.
Right,
Uphold the
right.
termination or don't
Right.
uphold
The recommendation of us upholding the termination or not upholding the termination. So, we
The
need
outcome.
Go ahead.
Just a question, the outcome of not upholding the termination, then we would be reinstating?
Yes,
Is
sir.
that what
Then-
happens?
Then you've reinstated the employee.
Okay.
Okay, so do we have I would ask for a motion on this
Yes,
one. Okay, do we have a motion to uphold or not uphold the recommendation of the superintendent?
After that motion goes one way or the other, can we make in a separate motion, recommendation or direction that those negotiations on the other issue take place? We can't order them to do that, can we?
You can't order that. You could authorize a discussion of that between the legal counsel and the district to be considered, yes.
Okay, and once we make these conclusions today, they come back to us for another meeting at a further date after you've written up everything.
To enter the final order consistent with what you do today. It's not another hearing to change anything. It's
Well-
just to enter the final order.
It's a hearing to enter a final order, but.
That's correct.
Are you saying there is no option to not enter the final order? Otherwise, why are we having a
No,
vote at all?
you have to enter the final order.
But that's the point I'm making.
Yes, sir.
So in between then and now, it gives the group an opportunity to talk about that issue.
That matter may not be included in any final order. It may be a separate issue that's discussed.
Okay?
Okay. So, do we have a motion? Okay.
So I'll make the motion
What would be your
to
motion?
uphold the termination, so we can finish this and we can move forward with other business later.
Okay. So Dr. Kelly has made a motion. Do I have a second?
I'll second.
Dr. White is second. All those in favor, state, raise your hand.
Discussion.
Oh, discussion, I'm sorry. Do we have any more discussion? Thank you, Dr. White.
Okay, can you just clarify what we're doing here? Your motion is that we go ahead and vote for termination or not termination. But the piece about whether we're going to do a severance and cutting and all that,
That's not on the table.
okay.
That's not a subject of this
Not a
motion.
subject to this motion.
Okay, so this would be something else.
Yes.
And that is something we can take up today? Or
We could
you're
make a
saying?
separate motion after this.
Oh, okay, all right.
To authorize the
That's correct.
superintendent to enter into those discussions.
Okay.
Okay. So once again, we do have a motion by Dr. Kelly, a second by Dr. White in favor of upholding the termination of Mr. Johnson. So any more discussion? Okay, seeing none, we need a vote. All in favor, raise your hand. All opposed? Motion carries 5-0.
Now, I will make a motion to authorize the superintendent to go forward with the discussions about contract severance, whatever we want to call that term.
Okay. So Mr. Destin has made a motion on the floor that we would allow the superintendent to come up with would the correct terminology be a severance package, Mr. McInnes? A severance?
But we'll let them call it what they want.
I think he's just asking that discussion take place.
Okay. So how should we word that then? Just,
Need a second?
no, I just want to make sure I say the motion correctly. So go ahead, say one more.
Well, the motion is to authorize the superintendent to enter into discussions with the opposing party
Okay.
on contract
Okay.
severance.
Okay. So Mr. Destin,
Well, at this point, it won't be contract severance. The
Right.
contract's been terminated. This would
Right.
just be further legal discussions on
Right,
that.
on compensation
Right.
under the contract. Well, how would you even say that, Mr.?
I think that's what I was wanting.
Yeah, we're venturing out into
Uncharted.
uncharted waters with other discussions, but the bottom line is those are discussions that can be held in regard to whether there are appeals, whether there are actions,
Right.
things of that nature.
Okay. All right, so Mr. Destin has made a motion. Do I have a second?
I'll second it.
Okay, Ms. Ivanchek has second. Any discussion?
Well, I have some questions.
Okay.
So if I understand the motion correctly, and I want to make sure I do before I vote, then I think what Mr. Destin's motion does is authorizes the superintendent to enter into discussions with the former employee regarding what? Compensation?
Compensation for the remainder of the contract period, but that doesn't make sense either, does it?
No.
Sorry.
Well, just enter for compensation then. Is that what we're authorizing?
Mr. Larkin, you can help us?
If I may. All right, so now that the decision has happened, I don't know that a motion and a second and voting is necessary. I think you could just simply direct the superintendent to explore or negotiate with Mr. Johnson an opportunity for us to resolve any future
A
liabilities.
resolution is really what it
Okay.
is.
Yeah, and so obviously whatever we negotiate would be subject to the board approval.
Okay.
And it may or may not be at whatever dollar amount, or so whatever we come up with, we would present back to the board, and the board can accept or reject it or modify it at that point in time. But it would at least allow us to have the calm light of day to sit down and, I mean, there's issues that he's brought up that we don't know the answers to right offhand, and so we would have to, determine that. But I think,
Okay.
I think the motion or the directive would just be to have the superintendent explore resolution options for future liability.
So moved.
Right, so we have, I still have some questions, Mr.
Okay,
Clark.
so, but real quick, that, should the motion be withdrawn since it's just a recommendation as far as that what he stated?
Still have to move.
We still have to vote on that?
Yeah, I think it's just a motion to authorize him to
Okay.
have those discussions for resolution of.
Okay. Okay, so-
Outstanding matters.
Yes,
Right,
okay,
correct.
so I just want to make sure. Okay, so we do have a motion and a second. All those in favor?
Well, I'm not done with
We
mine.
still
sorry,
have
I'm sorry.
discussion.
No, I'm sorry.
I'm
Go
done.
ahead.
So I understand then that there are outstanding matters that will be discussed and that those may involve compensation, okay? For what? Contract, remaining contract?
Release of liabilities.
Okay,
The
release of
other side
liabilities.
That's the bottom line.
That's it, has the ability to appeal this to the circuit court.
And I think I heard Mr. Larkin say that would then come back to the school board.
Sure.
Should this motion pass, it would come back to, would that be like in a regular meeting, or would it be a separate special hearing, or how would that work?
It would just be in a regular
Board meeting.
meeting.
Okay, and it might be something on the agenda that would specify, I guess, what the arrangement that you reach is?
It's my understanding, and I guess the question then becomes is whether the appellate avenue that he still has remaining, would this constitute pending litigation?
If in fact we went that way, there could be an executive session, but it's unknown to me yet what status it's going to be in, Dr. White. So it may very well be in a public meeting, it may be in an executive session. Even in an executive session, you have to come back into public meeting to
Right.
vote.
Yes, sir, I understand, and I just want to make sure that before I vote on something, that I
Sure.
understand what I'm voting on.
Sure.
And so, you mentioned appellate, and would you discuss that so that I understand what you mean?
Well, it's my understanding that now we have a final agency order, essentially, as if sometimes there's an arbitrator decision, sometimes there's a Division of Administrative Hearings Officer decision, and when we finally get a final order from the board, which we do today, now have, then there are appellate rights that are offered to the employee to take this matter
Our decision.
up to the First District Court of
That's
Appeals.
correct, and that's a part of our final order, and it's provided for by the statute.
And isn't that where normally these things, these agreements and these compensation packages or whatever they are, isn't that where those things are normally determined rather than at the board table?
They might very well be discussed in a decision as to whether someone is appealing or not appealing, yes.
But instead, I think what we're talking about is we'll just do that here ourselves.
Now, I think what we're doing now is simply, you've taken final action on the recommendation, which is what you needed to do, You're not involved here in negotiating anything. You're just simply signaling to the superintendent that those kind of discussions would be acceptable to you.
But that would come back to us for approval
Yes, sir.
or modification.
Yes, sir.
As happened here today.
Yes, sir.
Well, effectively, I guess.
Yeah.
Well, I just have a lot of questions about all that. I can't remember a situation that this has ever happened. Can you, Mr. McInnes? You've been the attorney to the board for how long, how many years now?
I mean,
30,
I've
40?
I've seen the board on occasion modify recommendations, but that's one reason I'm suggesting that your action today be just to act on the recommendation and let these other matters be discussed separately outside of this hearing.
So what happens if they can't reach an agreement?
You're not ordering or directing it has to happen. You're just signaling it may happen. It may not.
But Mr. Johnson still has rights that he can
Absolutely.
exercise
Absolutely.
in another venue.
Yes, sir.
Is what employees typically do. They exercise those rights in another venue beyond the decisions that we make here.
And in this case, it would be the appellate courts.
But I think what I've heard suggested here is that we would do that, or the superintendent would do that with counsel, and there'd be no need for that, basically.
If an agreement can be reached, but you have to remember, if they should exercise those appellate rights and go to the circuit court, everything we've done today could be overturned. And we could
Absolutely.
also be subject to damages. So what we're telling the superintendent is go talk to them and see if we can reconcile this in a point that everybody will be happy with to avoid that possibility.
And I think we all understand that when a decision is made at this board table, that there's always the right of appeal, is my understanding, to another venue, whether that be a court or whatever it might be, as Mr. Larkin has already said. I just find this very unusual, very, in my opinion, very irregular, that this board would do that. And I don't know what kind of precedent that sets for the future in future terminations.
I don't know that a motion is necessary to do what you've talked about. I mean, I can't say that you can't make a motion, but I don't.
Well, there's
I don't
one
know
on the table.
It's necessary.
There's actually a motion and a second. And I think, quite frankly, for public interest, it ought to be voted on. So unless somebody withdraws it, I don't know what to do except vote on it. But that's just one board member's view.
And you have to understand that we are not telling the staff to do anything. We're authorizing them to talk to the other side. And I don't know what precedent that says. We should always be prepared to talk to the other side.
I think I just hear Dr. White saying that really can happen whether or not there's an action by the board. I mean, that could be part of, is part of any proceeding once you move on to the next level.
Exactly.
It is.
It's their responsibility to take it to the next level if they choose to. But that's just how I see it. I'm sure I'm wrong.
I'm not sure about that part.
But I thought we were going to looked at termination or not termination, then we were going to look at severance or compensation, whatever we're going to do, but then we had the break, so they determined that they didn't want to do that?
I think it's determined that the board needs to take action on that, on the termination recommendation, up or down, and then leave it to the parties if there is some other discussion because of potential future liabilities or future appeals or anything like that. Let that be discussed in a setting outside of a hearing. It's not fair to anybody to have to, put that kind of pressure on them at this point.
And you probably don't even have all the documents that you need at your hands.
Yeah, to sever that compensation relationship, right? Is that
No,
what you're saying?
You've done that. You have voted to
Right.
terminate the contract. That is over.
Okay.
Now they have a right to appeal that.
Okay.
And these other discussions could occur in the midst of that process.
So they can move it to a different court, okay? Or they could just have a discussion with the district, at which time the board would have to approve
That's
that
correct.
decision.
That's correct.
So right now, it seems to me that it's out of our hands, right?
Yes, ma'am. That regard it is. Your duty today is to take action on that recommendation, which you've done.
So that other action really doesn't have to be a board action. That's what they're going to do. And so until something comes back to us, there's nothing for us to.
That's correct.
Okay. So what is our motion about then? Just allowing authorizing the
That's what I'm saying.
superintendent to have that?
I don't know that a motion really is necessary to do that.
Because he's going to be able to, he'd have to do that anyway.
You have the ability.
Okay.
Any further discussion?
So is there still a motion on the?
There is still a motion and
Okay.
a second.
Unless
so-
someone wants to withdraw the second.
Unless somebody wants to withdraw the second
Okay,
or the
and the
motion.
motion is just authorizing the superintendent? But there's really no need to do that?
That's correct.
Right.
Okay, then I withdraw, I think I made the second on that one, so I'm going to withdraw that,
Okay.
knowing that he already has that authority.
Yes, ma'am.
Okay?
So Ms. Vancheck has withdrawn her second. Does anybody else care to second this motion? Okay. Seeing none, the motion fails, and I will be passing the gavel back over to Chairman White.
Thank you, Mr. Bryant. I felt like that was appropriate since my motion didn't receive a second, so that I could just step out of the chair role and try to be like everybody else. All right, so Mr. McInnes, I'm looking at the agenda here, and I see item 2.5 was board action. Section 3 is adjournment,
That's
unless
correct.
there's anything else, sir, that we need to cover.
No, sir.
Colleagues on the board, anything else? All right, we're adjourned.